could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
So the date has been set in the Karmelo Anthony motion to recuse Judge Cockroach. It's set for August 19th in Collin County, 9 a.m. And it's not restricted from the public. So that means you need to be there. Because we recall Judge Cockroach attempted and succeeded at limiting people of color from having access to make sure that justice was administered fairly. So what does that mean? That means that you need to prepare to be there in support on August 19th. So essentially what that means is that you want to attend, you need to prepare to be there. Because the clear people are going to attempt to do exactly what they did under the power of Judge Cockroach. So make sure you show up, you be prepared, because we want to make sure Judge Sid Harley removes a legal lynching judge who violated his oath of office when he decided to take his clear ass on the news and tell us exactly what he did. The date is August 19th in Collin County, 9 a.m. Show up to support Karmelo Anthony, his legal team, and his family.
All right. Let me get myself on the screen. Blessings, and good evening, everyone. Welcome to Grace Uncensored Live, Deep Dive, whatever you want to call it. Thank you for stopping by. Hold on. Let's make sure that you got, okay. And let's get this off the screen. So today we're going to be reviewing what happened the last 2 to 3 days of the Karmelo Anthony trial. Let's replace this picture real quick. Get a nice image up there. And as you see, the title of this video is, Did Karmelo Anthony Get Railroaded? Jury Held Hostage. So as you know, I've been kind of doing it the easy way because there's a lot of information in the filings. The last couple of deep dive, we showed you where you can get the filings, where you can review them yourself. So what I did was put them in a podcast form for you for the, I believe we're going to be listening to June 6th, 8th, and 9th. We're compiling it into one podcast, and it's just amazing, okay, because it really captured exactly what happened between those days. And you do know that one of those days fell on a Saturday, and there were some circumstances surrounding that. And we're also going to get into the two motions that will be coming up, one for the 19th and one for the 20th. One motion is to recuse Judge Cockroach, and also the next motion is for a new trial. Now, y'all know, if y'all don't know, this is how I feel, but I love to report things unbiasedly. If you don't know who I am, my name is Miss Grace. I'm not a Democrat or Republican. I'm a separatist, and I separate from the BS. I'm actually a Hebrew. Okay, I wanted to play some music this time. I'm gonna play it at the end, okay? Because I didn't want to culture shock everybody, but I got some ruach for you. But with that goes to say, what I do here is report things unbiasedly. I am not a lawyer. What I like to do is legal research because I have a background in legal nursing consulting, and what we do is look for liabilities. I was one of the best, one of the best, one of the best. They used my care plan as a point of reference for the students when I was in nursing school. That's when I knew that I love to pay attention to details and create reports. So, what that goes to say, you're going to see what we unpack here. So we're going to flash back to kind of where we left off with the trial, because there was some controversy around the trial, at the trial, outside of the trial. We're going to review that. We're going to get into some of the buddies' testimony, and I'm going to talk to you guys from Mama Grace stance, and from a non-biased perspective. But I said you got to choose your friends wisely. So we're going to get into some of their testimony, and then we're going to get into what the jury actually was subjected to and what these motions entail for tomorrow and for the 20th. Okay, so let's get to it. I want to say thank you so much for being here with Miss Grace, and I'm doing this because I feel like it's very important that someone and all of us actually, continue to push the truth about what happened to our young brother. Okay. Now, before I play this video, I do want to give y'all my opinion. I do believe, just like Karmelo Anthony said, he is guilty. I did it, but I do believe it was done in a heat of passion, done by a young man who didn't have the critical thinking skills that we had, toppled with the information that we found out that came out in the trial. He had epilepsy, highlighting that he takes medicine. There's cognitive changes, as well as there's a risk for life-threatening bodily injury if he gets into fights. Now, what that goes to say, when I first did the first video, because I think this is going to be the last one until we hear what happens in the next 2 days. I got to take a little break. Okay, I got some stuff to do. But originally, I was asking, would Karmelo be charged with manslaughter, or would he be, given the full penalty of murder? And as you see the outcome, I was not surprised, but surprised. I was not surprised because of the system. I was surprised because the system was supposed to do its thing correctly. Now, I do believe that the sentence was too harsh. I believe that he should have been sentenced for second degree or manslaughter, which would put him between 10 to 20 years, which would have been fair. This is my opinion. But now there's so much things that's coming up about what happened in the trial and the mishaps. It is alleged that his legal team and Karmelo Anthony has grounds for a possible appeal. And right now we're going to be looking at the motions. Now, before we get into that, I have to tell you guys, as I feel about the appeal, looking at, and I'm going to go deep into it before I make a definitive decision. That's what I'm going to be doing, reading this case over this week. I don't feel the representation of this case, the way it was represented and everything that was put on the record. I don't think it would be safe to go for a general appeal or case review. Why? Why do I say that? Because they're going to look at the transcripts. You can't introduce new information. Everything that is there is there. And the reason why I say that is that the first few lives that we showed you the last couple of days about Karmelo, it was heart-wrenching to hear AI put a podcast together that basically highlight that the defense got railroaded. Okay. They didn't even put up a fight. Now, when we listen to the motion, we're going to kind of understand allegedly why they didn't put up a fight, because it was related to the quid pro quo, the sweetheart deal, or whatever deal that they made amongst each other. Okay. These two lawyers. So with that goes to say, that's just how I feel. I pray that Karmelo gets justice, meaning that this harsh sentence get reviewed, it gets lowered, and if it gets turned over because of administrative error, oh well, oh hell, we just got to figure it out. I'm down for it. So hit the like button. The first thing we're going to do is take a flashback to the first interview that took place with Mama Anthony and his father. Okay, I have to bring the humanism to this before we just cook on it from a legal perspective. Okay, and remember, people, We purple. We purple up in here. Meaning that's how we think and address stuff. You can't put whatever you want in the comments. Well, come on, make it make sense. You know what it is here, okay? I love you guys.
I don't have to prove anything to nobody. I am a proven testimony standing here that God, even when you make mistakes, God is not finished with your story. I'm going to bring this mother, Kayla Hayes, and it has taken her a lot of strength, y'all, to come and do this today. And I want you guys to respect her as she read this and giving her the respect that she deserves, y'all.
Now we're going to listen to this for a few minutes and then we're going to play what was happening in the background, okay? Because it was drama from the beginning with this, okay?
Good afternoon. My name is Kayla Hayes. I am the mother of Karmelo Anthony. 3 years ago, my family moved to North Texas searching for a better life. Like so many other families, we wanted to give our children the future we did not have. My husband worked hard every single day to provide for us, to make sure we're in the best financial position possible. As a stay-at-home mom, I made it my life's mission to ensure our children are loved, nurtured, and supported every step of the way. In wake of this tragic incident, our family has been under attack. Whatever you think what happened between Karmelo and the Metcalf boys, my 3 younger children, my husband, and I didn't do anything to deserve to be threatened, harassed, and lied about. The lies and false accusations that have been said about us, especially over the past week, has been overwhelming. The lies and their amplification put my family in danger, as well as everyone in our community, everyone involved in the investigation, from the police, the attorneys, and the court staff. Our address and my husband's previous employer's address has been put on all social media platforms. My husband had to take a leave of absence because he's afraid what may happen to our family. His mental health is deteriorating day by day. We have endured death threats.
Oh my God.
13-year-old daughter is afraid to sleep in her own bedroom.
And I'm gonna stop right here because I don't want to get too emotional, but I'm just here thinking back of all of the things that the family went through, the whole situation until, I mean, celebrities got involved, crackhead, fake celebrities went to get involved, act like they was raising money, flipped it on them, just as a whole bunch. Imagine being in a place like North Texas. And I made that face because she was like, I moved to North Texas for a better life. And that's what I'm going to say to my brown melanated people. Okay. Ice is not always colder on the other side. You can't pick a place that's neutral, multicultural, do good background about the places that you move into. And I think some of these things could be avoided. And I'm being honest, because when I moved to Georgia, I was going to move to Marietta. And it was nice. I had the money to do it and everything. But then I saw the behavior and the culture out there. You know, a whole bunch of bougie, privileged people. The cops was following me. I had my nursing uniform on. I was like, oh my God. Then I was having trouble finding apartments. I made 3 times the amount of money and it was issues. Y'all be aware, because us as brown melanated people can avoid some of these things by starting to, you know, live separate but equal. If y'all know how I feel, I'm just letting y'all know I'm good with separate but equal. Separate don't mean I hate you. It means you do you and I do me. If y'all cultures are different, our cultures are different, and we can't feng shui, or you have an innate hate or dislike for certain things, then We should be able to be separate but equal. So I just wanted to add that because it hurt to kind of hear this, because this was at the beginning. And then they went through a whole roller coaster being, yeah, this is who she is. They're using the money for this. They're running for their lives. Like, it's a genetic hate disposition for some of the people who watches this. Not only allegedly the people involved, we're not talking about the Metcalf brothers, but the people who watch this, and they need something to hold on to, and then they go attack, antagonize. Okay, just like I said with Judge Ashley, I think that was a setup with those people. Those are people who are antagonizers. They wanted something to hate and hold on to. This was really hard to kind of like deal with. So I want to send love and blessings to Kayla, to her husband, to the Austin family, and the Metcalf family. We want to get into it. So let's play a little bit more, and then we're going to get into what Austin Metcalf dad was doing. Okay, I'm trying to send him a little love, but he was on a little bit of bad behavior from the beginning. From the beginning.
Because she's fearful of what might happen to her. And let me be clear, the claims that were used about the public donation to buy a home or anything else are completely false. We have not received a single dime from the Give, Send, Go fundraiser.
And if they did, as I mentioned, they should be able to use it for their safety and for Karmelo's case, period. They have to be alive for the estate. So we're going to move forward, because that's some of the propaganda that surrounds these cases. And that is just to stop us from donating, people who are in the bad situations. Let's give example, because we purple here. COVID. What did they do during COVID? Some of the people who were organizing, trying to get money together, because it was everybody get together, huh? I loved it. But they were stopping fundraisers. They were doing, this is the same MO. And then we get involved in it as the people who watching it and fuel it and use it selectively. But I'm going to move on now. What I'm going to show you is what was going on in the background now, okay? Because this was the reason why the judge allegedly had to basically put a gag order. Hold on one second. Let me make sure I got the right one. Put a gag order on this case allegedly, because these things started happening and it started to turn into a circus. It wasn't just the people on the outside. This is why it was a gag order. Let's play this real quick.
So Austin Metcalf's father decided to show up at Karmelo Anthony's family's press conference today. Most people are saying, well, he had a right to be there because his son is the victim. And I say that has still yet to be determined. Next, nobody's showing up at all of his conferences and things that he's saying or the stuff that he is doing for his child.
Shout out to Michi X. This is on Michi X channel.
Okay, so he didn't have the right to be there. It was a private conference so that they could address some things with the media. It was not open to the public. To me, it also shows the fact that he thinks he can come into this family's space with his presence because, oh, my son, he got killed. It's kind of bullying. It seems like that's where his son got it from, that even when you don't have the right to tell people what to do, you still want to exhort yourself in someone else's face as though you're going to force them to listen to you or let you be in their space. It's probably the thing that got your son killed. So now at least we know where he got it from.
No comment. I don't promote death. I don't promote violence. Okay, guys? Y'all already know how I feel about fighting. I feel about bullying. I don't promote bullying. I don't promote fighting, because fighting leads to death. That's where I'm from. That's the only time we fight. Okay? So I don't promote it. It's this guy. Now, being honest, we all purple. Let's just be as civilians here, okay? Because that's how we look at law. What would be the most common sense approach to the situation? What would the majority of the people do? Now, I know we have this crazy tone in America right now, Epstein world, but before all that, let's just think about, law abiding citizens and us just kind of wanting to feng shui and not cause problems. Do you think that this was appropriate? Okay. I would think a countermeasure, and this is why I do believe the judge did, have grounds to put a gag order, because it was about to get ugly. He already knew allegedly what he was dealing with. Okay, the Metcalfs. Okay, the Metcalfs, which is allegedly a prominent family out there. Let's watch a little bit more. Was it appropriate? And I just want to add this. I believe that he could have had his own meet the press. You know what I'm saying? If he wanted to counteract it, if he wanted to say anything. Look at my man. My man being a weirdo. All right, so that's enough of that. Now, this was some of the background of what was going on. And like I mentioned, I do believe this is why the judge did what he did. So, as the trial went on, at the beginning, it was supposed to be open. And then the judge restrict things, got stricter. And then it goes into the motion that we'll be hearing about, because that is some of the issues for pushback on the way he handled the trial, the way he shut things down, and the way he locked certain people out. Now, I will say we watched that on TV, YouTube on TV. We watched that in real time with some of the content creators, because they literally was complaining about being ditched in line, cut in line. Certain people were getting in, being picked, and they were part of allegedly the Metcalf. And this was documented in real time. Some content creators being harassed. We're going to get to a little bit of that controversy, but we have to set the undertone of what happened the last few days of the trial between the 6th, 8th, and the 9th. Okay, so that's where we setting the tone. So let's watch this real quick.
Full trial really finally received the emotion of this full trial, really finally was able to be released in the victim impact statements, as 4 of Austin Metcalf's family members finally released from a gag order, finally able to express themselves. The impact statements happen after the jury's verdict, after the defendant is formally sentenced. So these statements are really just a chance for the victims to face the defendant and be able to let all of these things out. So the mom, Megan Metcalf, gave a very emotional but strong statement as she faced Karmelo Anthony, telling him how she used to have a house filled with energetic 2 boys full of laughter, and now her house is quiet and the laughter has been turned to screams, and all she has of her son Austin's voice is her memory and videos of him speaking. And she talked about,
she said all she had was screams. I'm sorry, I had to add, I'll be listening. Why are you screaming? Dysfunction. I know. I have dealt with parents who lost their child, honestly. Talk to parents on the phone and you'll hear them vent, and I never heard someone screaming and yelling, even when they were talking about the person who they allegedly hurt their kid. So that's a sign of tension. I pay attention to details. I'm like, oh, nah, I don't like that. My kids be like, you pay attention to too much. I'm like, what'd she say? That's tension right there for me. But I'm going to move forward, because that I want to highlight that, because though that was one of the main things that was held out of this case, allegedly, the tension of Austin. So that's why the legacy media found it their business to highlight the tension of the father, the mother, what they were seeing, things like that. Then the cheerleaders came out. Okay, so this is some of the outside scenario, what was happening around this trial.
The morning that she had given them breakfast and packed their snacks, and she got the big bear hug from Austin. Certainly emotional moments in that courtroom as she told these things, and she made this statement: you have been given a sentence of 35 years. You should feel lucky. I have been sentenced to a lifetime without my son. Next to take the stand was Austin Metcalf's father, Jeff. He had a video up playing photos of his son, Austin, over the years, many of them with his brother who was there in the courtroom also. And
I never saw that before. That was something new. Did y'all hear that? He had a PowerPoint playing. I ain't never hear victim impact statement do that, but y'all let me know because I haven't attended a lot of or either any victim impact statements, but that was weird. Okay.
And he talks about their faith helping them to get through this, but also he came to a shout telling Karmelo Anthony, we were robbed, and to suffer such a loss is tragic, and how this whole ordeal has just taken a part of himself, and he is not the same person anymore. And he said that his son's death didn't just change who he is, but it destroyed the person who he used to be. And then it was very impactful as Hunter took the stand. We did not hear from him during the trial, as many were expecting, and he took a very respectful tone. The father of Austin Metcalf had really pointed out that he wanted Karmelo Anthony to look him in the eyes, and Hunter did the same thing, asking in a polite way that he would really appreciate it if he would look at him as he had his statements for him. And he said that you still have air while my brother is 6 feet under. But he went on to
Oh my God, this is hard. This was hard right there.
say that his brother's legacy will continue to live on. The family later appeared in that news conference that we showed you, but they chose not to take any questions tonight.
Okay, so just imagine this, because we purple here. We're just kind of thinking. You're thinking from Karmelo perspective, and then we're thinking about from the Metcalf perspective. Let's not think about persons, personalities. But, to actually lose a child, to lose a brother, it is a lot. But then you got to think about the Metcalf surviving twin who knowingly in his head know that something happened that hasn't been exposed, because what we showed you, he was suspect in all of his interviews. I mean, and this is why I believe they did not put him on the stand. So let's just all think about this. This is like a soap opera. I grew up on soap operas, with grandma. Okay, so you got that going on where he's like, "Look at me, I'm trying to be like my dad," but then imagine Karmelo look at him like, you lying. Okay, and then you got dad with all of the emotions, the cinema, and look me in my eyes, and the projectile up there, screen projector. I've never heard about that in my life, but that's there. This is a lot. That's why I said, "Whoa, this is a lot. This is a lot. It is a lot emotional." And then we're going to get into kind of what was happening outside. Okay, let's get into what was happening outside, and we're gonna play this scene up. This is serious. Okay, so this what was happening outside. Let's see. Hold on a second. Don't you do that to me. Give me 1 second. Let's switch this over to the next screen. Thank you for being with me. Please hit the like button. If you guys don't know, you'll know now that I'm not monetized and I don't plan to be monetized. Okay. Shout out to YouTube. I love you guys. We just have, we have different opinions, and I have control issues. So what that goes to say, I'm here free. My sponsors will come on the page, go down into our gift shop, buy a Freedom hat. Okay, that's how you can support, and hit the like button, turn your notifications on. Okay, so this what was going on outside. On top of that, I'm gonna add on to what else was going on, because I don't know if they mentioned Jake Lang antagonizer. I don't even have the clip. It was so much. This was bad. Like, it was just bad.
McKinney, Texas, with the latest. Hi, Brooke.
Hi, John. Well, the jury just returned from a lunch break. There are cameras not allowed inside the courthouse. But if you look behind me, check out what's happening outside the courtroom here. You have protesters on both sides. They've been arguing with each other, antagonizing each other. We have the sheriff's office here making sure that things don't get out of control. This case, it has sparked some strong emotions. Karmelo Anthony's defense today arguing this
is what I say. Them outsider antagonists. I think people are paid antagonists. Again, y'all know what was happening before. If y'all wasn't watching the conspiracies before, it became a cool thing where they had ads for people to go and be stage props for these type of things. But now they have professionals that I believe they fund, they give platforms, and these people come from certain backgrounds and families, and they there to represent something that causes chaos. This guy, for me, I'm just going to keep it moving. let's just play this. Just know that he's got banned from Texas after saying that he wanted to hang Carmelo Anthony. This is how far and going we are as a nation of people, that literally we don't have any democracy or any, I guess, belief in the system, that we have to take it back to the good old days. You know what I'm saying? I'm smiling. This is how Black people can smile when we talk about slavery. I'm sorry, I gotta, so crazy. It's in my DNA. Talking about hanging Carmelo. A few of our ancestors before were pulled out of courts, jail, hanged by mobs of people who were just picnicking and going to church and wasn't even tried. Okay, I'm sorry. That was post-traumatic stress. Let's move forward. I can't. That's why I watch certain things, because it does that. It does that. It does that.
This is a case of self-defense. Prosecutors, on the other hand, calling it a, quote, provoked, unjustified murder. 17-year-old football star Austin Metcalf was stabbed during a high school track meet back in April of 2025. Police say the confrontation started when Metcalf told Anthony he wasn't supposed to be in his team's tent. Investigators say it quickly escalated, ending when Anthony pulled out a knife and stabbed Metcalf in the chest. Anthony has pleaded not guilty to murder. Race, though, as you mentioned, it's become a major issue surrounding this case. Supporters raising hundreds of thousands of dollars online for the teen charged with murder.
We came by plane, by bus, by cars. We traveled.
But today in court, prosecutors said this is not a case of race or self-defense. They said that Metcalf was unarmed and argued that Anthony provoked this fight and pulled out a hidden knife. Metcalf's twin brother and mom previously spoke to Fox.
He always was wanting to step up and be the person that would do the right thing. And he was doing the right thing by saying to this gentleman that you're not supposed to be in this tent. This is because they have personal items there.
And John, back out here live, we're going to keep an eye on what's happening between these protesters and supporters on both sides. Inside the courtroom, I'm told that they're starting to hear witness testimony, including some surveillance footage.
Okay, so this what was happening. Things started to escalate outside of the courtroom. I want to send a shout out to Neek at Night, because she was out there every day and she went through detention. She even was accosted by allegedly some of the people who was connected to the Metcalf family. There's some people actually named in the appeal. Okay, so I don't know Neek at Night real name, but it's at least 2 or 3 people that's named in the appeal stating what they went through when it came to the line and the fairness and how they were picking people to get in when the judge started to restrict things. Okay, so this was what was going on. I'm kind of showing y'all the good side of it, because it was disgusting. It was disgusting. That's Mama Grace. It was too much. Okay, baby. Okay, so this is a clip that I'm going to bring to you from Chronicle Speaks. Shout out to Miss Chronicle Speaks. Okay, she did a great breakdown on day 3. We're going to listen to a little of it, and then we're going to get into day 4 of the testimony, a little bit of the testimony, listen to a few clips, and then I'm going to put up actually just a few bulletins of the testimony of 3 of Carmelo friends. Okay, that's why I say we got to be really careful. That's why I'm so funny of that friend of me, friend of my friend, of my enemy is my friend. No, hell no. If my alleged enemy and you don't like them, then it's cool. You don't like them. That don't make me and you friends. Or someone has this weak looking disdain where it's undertones and statements made to you and y'all friends, and they messing up your clothes, they fucking up your car. People, we got to have some discernment. So I'm bringing all this up right now because the way that it was presented in court about the situation, you can tell that it was a bold-faced lie. And I'm going to give you the reason why I think it was a bold-faced lie too, because I found something to back up my theory of why these kids lie. So I'm getting ahead of myself, but let's listen to this real quick on day 3, and then shout out to Chronicle Speaks. Hit the like button, please.
Court is in session on a Saturday. This is trial day number 3 for the Karmelo Anthony trial. Now, the first witness to testify on Saturday was a 17-year-old Memorial High School student who was present under the memorial tent on the day Austin Metcalf was stabbed. Although he was initially under the tent, he told jurors he was walking down the bleachers when the actual stabbing occurred. Now, the witness testified that Karmelo Anthony's presence under the memorial tent immediately stood out to him. He told jurors that it threw him off to see Anthony there because students typically stay with their own teams during track meets. Now, according to the witness, Anthony entered from the top right side of the tent and sat down among memorial athletes.
Now, the way she's mentioning it, it sounds much different from some of these kids' testimony. Some of them said he went in the top right corner looking suspect and not talking to people. We're going to get into it. It was a little bit horrendous.
As the testimony continued, the witness described Austin Metcalf asking Anthony to leave the tent. Now, he testified that Anthony was provoking Metcalf during the exchange and recalled seeing Austin place his hands on Anthony's shoulders. However, the witness did not describe seeing him fight or any large group surrounding Anthony fighting him either. Now, one of the prosecution's key points came when the witness was asked about weapons at school sporting events, and he agreed that students know they are not supposed to bring weapons to a track meet and told jurors you don't expect anyone to get stabbed at a track meet. He also testified that he did not see anyone crowding Anthony, and he did not expect a fight to occur and did not see a reason for Anthony to use a knife.
Now, let's stop right here because I do have some footage that we zoomed in on our last live of the altercation. And what these witnesses are saying is a dead up lie. We saw the crowding that happened around Karmelo Anthony. I also showed you in the last live, you go back and watch it, there were people across the field, grown adults just looking, hands crossed. For a few minutes, you saw one person's foot go up on the bleacher like somebody was seeing something go on. And so for that guy to say, oh, one, which is nonsense, he touched his shoulder. When you're telling somebody to leave, you're not going to touch them, period. But then you're not going to lightly touch them. That's the crazy part about that. And then he goes on to say, basically, no one crowded Karmelo. So let me put this clip up here real quick. The Karmelo zoomed in. Let's see, can we see it? Ooh, is this it? Oh, I think I moved it. Okay, that's what we're about to do. Let's go find it real quick. Give me 1 second, guys. Gotta go on my archive. God be glory. We'll have it zoomed in. Where we at? Day 2. Recording. Okay, let's play this. Now, this is the 2-minute clip. It is blurry. It is zoomed in. It is okay, so y'all remember my theory. It was 7 minutes of activity. We saw the Metcalf boys come in. Then all of a sudden, it's like 7 minutes between everything really like popping off. We see 2 angles, and that kind of, like I said, defense could have brought up the fact that it was raining pretty hard. The first entrance was blocked by a bunch of teenagers when Metcalf and his boys was coming through because they were trying to get in from the rain. And then today, I'm going to show you in some of the testimony, you'll hear some of them say that Karmelo was trying to find shelter and him and 2 of his friends coming from one place to another. So right here is, you're going to see, it's kind of like the first 1 minute of that 7 minutes. And then it was the last 1 minute before you see Karmelo take off. So this 1 minute, the Metcalfs had to be around there because they already came, and this was the video, the evidence that they showed allegedly in court. It was like a 13-minute video one, and the other one was like 10, and it was a 7-minute block of just us just looking, and trying to figure out what was happening. But if you zoom in on the tent, you're gonna see it gets thick. Okay, so this is at the beginning. I'm going to move it up because I don't want y'all to. I guess y'all got 2 minutes and 26 seconds of attention span. Okay, y'all do. Let's watch this together. If I had the Jeopardy clock. So we got 22 seconds right now. Okay. See that? You see somebody sit behind somebody. You can see an image come behind the tent, behind like at the top. And I believe Karmelo is already here. Okay. And what was missing from the pictures of the evidence was the full video of Karmelo coming in, walking to the tent, sitting down. Is not a full video. They got one video of Karmelo by himself walking into the stadium. And that's not, I don't think that's how it occurred prior to this, but that's just my opinion. So we do see within that 7 minutes, somebody in the back of this tent moves behind somebody, okay, or something. Now you see a little bit of movement in the middle. I need you guys to pay, and it's so blurry. This is what they were looking at when they zoomed in. And this was some of the argument of visually looking and listening and really understanding what was happening. All right, we have 54 seconds. We're kind of halfway through the clip. And I think in a few seconds, that's when I kind of, now look at the middle though. You see the space? I believe that in the middle, whatever this great thing is in the middle, I believe that's Karmelo. Everybody else look like they have darker colors on. That's my opinion. This is a really blurry video. This is a zoom in screenshot of the video of evidence. Okay. Now we have 1 minute and 25 seconds. We got one more minute to look at this, and then you're going to see something. Pay attention to the corner or like the top. I'm going to say, pay attention to the yellow. Now you see somebody just got up on the left-hand side. Someone else gets up. Okay. So it looks like someone moves in behind somebody and someone else gets up. This is when I think the first hit took place. And I think it was a break between the first hit and the second one, because within this video, you're going to see somebody slide next to someone. And I think that's when Austin slide next to Karmelo. We're going to watch it. Slide. Y'all saw that? Boom. Shortly, a push is going to happen. It's too much space in between this. This is the air. This is the space. This is the things that wasn't addressed. Who was saying what? What was saying? Who was saying something here? This wasn't a one-man band standoff to me. And that's why we're going to get into those kids' testimony on why they said what they said. And I think they were lying. We're getting at 1 minute, 60 seconds. Now, this is when things start to take off. And I think this is when Austin pushes him again or hits him again. Here we go. Push back. And you're going to see Karmelo get up and haul butt. It was a two-hit. It was a elongated situation. We're going to rewatch this. I know it's blurry, but you guys can actually go on. I'm going to share the URL. Go and look at the case. They have that there. You can zoom in yourself and look at it. Look at it yourself. This was what I was saying. Something was going on. I know bad kids. Somebody was mad at me because I made a post about a kid. And they was mad at me about, well, you see what? So what? She was bad. I was like, yo, she was bad. That's why they closed her arm in the door. And they was mad at me because I found the original situation. Her arm wasn't supposed to be closed in the door by the bus driver. This is a sidebar conversation because these people were trying to get on me. But when they realized what I was saying, I was like, yo, it's too mindful adults just let this little girl get her arms hit in the door. It's because she was bad. I know badass kids. So with that going to say, you saw somebody walk behind somebody. You see the crowd get thicker. The testimony is not the truth. So before I give you my 1-2, let's just get back to the Chronicle Speaks, because I wanted y'all to get a look at what I saw, what we showed you. Now, I'm not saying this is the proof and the facts and everything. Go look yourself. Go see what it say. I mean, what it looked like. This is what it looks like to me, honestly. All right, so let's finish listening to day 3, a few more minutes, and then we're going to move forward.
The witness recalled hearing someone yell, "He stabbed me," after the confrontation.
So you see, we broke that down really good. Okay, that's Karmelo running. Now Go ahead, Chronicle Speaks. Right on time, girl. Go ahead.
Said the scene immediately became chaotic. According to his testimony, he and another student ran away because they were frightened and unsure whether anyone else might be injured. He also told jurors that he saw Hunter Metcalf rush to help his twin brother after Austin had been stabbed. Now, perhaps the strongest testimony from the prosecution came when prosecutor Bill Worski asked the witness whether he believed the stabbing was an act of self-defense, which we've known he's asked that from every witness. Now, the witness answered no. When asked why, he explained his reasoning by saying it's lethal force against non-lethal force. However, the defense found several points to challenge during cross-examination.
Now, mind you, do you know they talking to kids? Young people talking about is lethal force versus non-lethal force. These are high schoolers, okay? Somebody had to say somebody asked, and they knew what to say. Now, I want to say shout out to Chronicle Speaks. I want y'all guys to watch the rest of this because we got a lot more to cook on, because I don't want this live to be so long. But in my opinion, what I mentioned to you guys, there is a law that if you're in the commission of a crime, felony, a fight, and somebody dies, I don't care if you were on their side, not on their side, you are held responsible now. So let's go into it, because I had to look that up. I was like, wait, I know it's a law. I know it's a law. So yes, there is a specified law allowing individuals to be criminally charged when they participate in a fight or a crime resulting in someone's death, even if they did not intend for the friend to die. So looking back at the video, I just got to look back. What happened in 7 minutes? What was going on with these friends? What were they doing? Were they trying to stop? These are the questions that they need to ask. So this won't apply to all of them. But I move forward. In a scenario like one described by the defense during the trial, where a group of supposedly attempt to jump and assault someone, the individual initiating the attack can face severe criminal liability under Texas law. The individual initiating the attack can face severe liability under Texas law. This is what it makes sense to me for them to just lie and say, he touched his shoulder. He just touched his shoulder. Y'all saw somebody slide behind somebody. Y'all saw somebody else slide next to somebody. Y'all saw some sliding going on. And in that 2 minutes, y'all lost your attention span because something was going on and we ain't know. Imagine 7 minutes of it. I'm just keeping it a buck. So the legal statute that applies to individuals who allegedly confronted or tried to assault Karmelo Anthony, this is aggravated assault. The law under Texas Penal Code 2201, a person can be charged with assault if they initiated the threat or harmed someone with immediate bodily injury or cause physical contact that they know will be regarded as offensive or provocative. Okay, so that falls under, to me, under that statute of what Metcalf did. You know, even if you have felt like you had the right to tell someone move out from under the tent, things like that, you was just being whatever because it's raining all hell. Your brother and you friends came walking in fast because it was raining. You had to go through a whole crowd of people who were blocking the entryway, which is a fire hazard. You're a team leader. You said nothing to them, and then you go over to the tent. And if you look at the tent, when we showed you, it was 2 tents. One other tent had a whole bunch of bags, but their tent didn't have a bunch of bags. You telling me that all these people ran and just grabbed their bags at the same time the kids did? So the scare of Karmelo taking something out of somebody's bag was ridiculous. So that's why I think this situation fell under this law, and that these kids testified the way they did because they really wasn't buddies. So aggravated assault, if the group used their numbers to overpower him, or if any weapons or severe threats were invoked. Nobody asked them, cross-examine, what did you do? And then what did you say? Did you say anything? Were you involved? These are some of the things that, as just skimming, because like I said, I'm going to read this again. I'm going to read it. Did they ask them that? And that's why I feel like if they do an appeal on this case, they're not going to win because they didn't put good things on the record. And that's just real. You know what I'm saying? We got to strategize here. They didn't put good things in the record. Based on the appeal, basically they said because of this good old boy agreement that the lawyer was submissive to, he didn't cross-examine them the way he wanted to. All right. 2. Felony murder rule, the law of parties. Under Texas Penal Code 1902, a person can be charged with murder if they commit or attempt to commit a underlying felony, and in the course of a felony, an act to commit that is clearly dangerous to human life, which cause death. Okay? How is it applied? If the group commits a felony assault against someone, and that victim defends themselves, resulting in one of the attackers being unalive, prosecutors in many jurisdictions can theoretically charge the surviving co-conspirators / attackers with a number of their own charges. This is because their initial illegal action directly set off the dangerous chain of events that caused the death. That's why, in my opinion, you had his bro nervous as all heck. He wasn't about to put himself in that situation, and they didn't want him to testify because he would have told that he started it and his brother finished it, allegedly. Now, this is why they allegedly wasn't charged. While the law exists on paper, Collin County District Attorney Office chose not to indict the other students under the tent. The state decision came down to how they interpret the evidence in the witness testimony. That's why they needed the witness testimony to be reflectors of this. And then it was one of the things that the judge said at the end was like, yeah, we got to push for, like, they forced them to go the jury. I'm talking about the jury. We're going to talk about him holding the jury captive. But when we listen to the podcast, he forced them, like, you ain't going nowhere, this, that, and the third. Also, the judge was just ridiculous. He said, we came too far. We're making it too good to stop now. He said something to this nature, and it was like, what? Like, this was a whole setup. Like, we got to run this. Like, let's go. So the prosecutors argued that the other students did not attempt to jump Anthony. But looking at that video, it looks like somebody was being at least swarmed. According to the state witness, Anthony entered the rival school tent. They had a track meet. I didn't even know that they was going against each other, but we're going to keep it like that. Anthony entered the rival school tent uninvited during a rainy track meet. When asked to leave multiple times, witness testified that Anthony verbally provoked the student to escalate the situation. And this is what I said, they don't need to bring this damn case on appeal, because the shit that's in here, y'all gotta know this law. He should have took a plea. But what I'm saying is, even if they won't be good on appeal, I think they have to do a sentence reduction, things like that. There are like panels in certain states that do bail reductions to go, because there be excessive penalties. So they have that in Jersey. And I'm giving you an example because my brother was looking into it, because at first my brother got locked up for murder. Okay, guys, I know the streets. God, forgive him for what he had done. So with that goes to say, the judge, they tried to give basically a plea bargain for 20 years, and he took it. But when it came in front of the judge to read everything out and get things going, they was going to do it consecutively and not concurrent. So that means that they were going to make my brother do each charge, 5 charges, 20 years. back to back. And the judge caught it. So if that didn't happen and the judge didn't court it, because the judge was like, wait a minute, that's not what you said. He said, no, you're going to do all of them run in consecutively together, 20 years. So what that goes to say, the sentencing, if they have sentencing reduction boards, people who look into that harsh sentencing in Texas, that could have been a route that I think that the lawyers could look into as well. I'm just throwing things out there, okay, guys? But let's finish watch this. I said a lot. We're going to get some of their testimony out there, and now you're going to understand why their testimony was so disgusting. And there's no such thing as a buddy friend. You need to know somebody love you. If somebody ain't about to ride for you and they like, this my friend, you ain't going nowhere, we leaving together, I don't care if they don't like you, this my friend, this my peoples, don't mess with them. That's why I roll by myself. Okay? I'm trying to tell you. I roll with me and God. Let's go.
Defense attorney Toby Shook established that Anthony did know at least one student under the memorial tent, even if their interaction was brief. The witness testified that Anthony and the student exchanged only a few words, but it contradicted any suggestion that Anthony had absolutely no connection to anyone there. The defense also highlighted events that occurred after the stabbing. The witness admitted that students later gathered on a school bus and passed around phones while looking at Anthony's social media accounts. Now, this line of questioning appeared designed to show that students were discussing the incident among themselves before all statements were collected. Or were all of these kids on the bus passing around someone's phone who had a video of the fight, but now that video is being suppressed? Now,
okay. Oh my God. That's why I said I want to read all of this. And then why I'm doing my broadcast the way I'm doing it is because it was just so short timing and life is on life. But if they actually had the footage that his friend E was recording, that E said that they didn't, and it's alleged that the cops didn't get it. If they have that, oh my God, I want to see it.
Another notable moment came when the defense compared the witness trial testimony to statements he made shortly after the incident. During a previous interview with police, this witness reportedly described Austin putting his hands on Anthony as a warning. Defense attorney Toby Shook attempted to categorize Austin's actions as intimidating. Now, although the witness did not agree with the actions being intimidating,
not only intimidating, Chronicles speak, offensive and provocative and provoking. Okay, which falls under Texas Penal Code 2201. Keep on speaking, sister. Let's go.
He did agree that Metcalf's size could cause some intimidation. The witness also provided testimony that differed from some other accounts presented during the trial. He stated that Austin and Hunter Metcalf were sitting next to each other under the tent, while other witnesses have described them as being positioned in different areas. Overall, this witness was helpful to the prosecution because he rejected the idea that Anthony was being mobbed, surrounded, or acted in self-defense. At the same time, the defense was able to establish that Austin did make physical contact with Anthony and that some details of the witness's account differed from other testimonies jurors have heard. Those inconsistencies, along with witnesses' acknowledgement that students were discussing the incident afterward, are likely points the defense hopes jurors will consider as they evaluate the reliability of the eyewitness testimony. Now, the next witness to take.
Now, I'm going to get to here. Shout out to Chronicles Speak. She did her thing. And also shout out to, as I mentioned, Neek at Night. She was there going through it. Okay. These people were acting like savages. So again, physical contact was established. And I do believe that the defense was supposed to cross-examine, reevaluate, especially if they were using these kids as experts. He just lightly touched him. What do you consider lightly? Can you show me the gesture? Was there anybody next to someone else next to him? If you were in that situation, how would you feel? Or I want to ask I had to ask better questions. You know what I'm saying? I have to get better on cross-examine questions. But there's some of the things that I would ask. Okay, judge, they were like, they were like, no, she can't say that. I'm just playing. Certain things you cannot ask, but they can't cross-examine. So the physical contact, this first witness did establish that he saw his teammate Austin stand up. He is in his peripheral vision. So what we saw in that clip that we saw, like I said, it was a break between the first movement behind somebody, and then it was another movement of the second one who pushed. So it's either, I can say, because we're gonna watch that video, it's either, because the way it looks like that same place where that person was set at, like the first seat, the second one slide right next to him. So it could be that was Karmelo that moved over from Austin, and then Austin came by him again. It could be two scenarios where you saw that gray looking object It looked like an object. I don't know if that's a person, but we definitely see somebody slide to the middle, like right there. Then we see somebody slide over next to him. Okay. So there is points of contention, movement, and blocks of air that we can't determine what really happened. Okay. So he said in his peripheral vision, he did see Austin did put his hands on the defendant. Does that not fall under the felony murder rule, the assault and aggravated assault law? Does it not fall under those two categories for this witness? All right, so the immediate aftermath is what we showed you before when you saw everybody went running and things like that. He said he turned back around upon hearing the yelling from both Austin and other teammate. Austin was yelling, "He stabbed me." The other teammate was yelling, "He got stabbed." The witness saw the motion of the stabbing, described it as an upward motion. So I was correct. He was like, he pushed him. It was like, chain. I thought it was, but maybe it was the upward. That's probably why he got him under that sternum, right in the heart. And that's why I say it was a deadly stab, but was it a vicious? I don't think so. The witness saw the motion of the stabbing, describing it as an upward motion from the defendant towards Austin's shoulder, trapeze area. So it looks like, from what this witness said, possibly Karmelo wasn't even trying to really go for the kill. He was just trying to go for like pull, like get him in the shoulder and stuff like that. Now, I would say, I don't tell y'all how to defend yourself, but never right here in the stomach. This person could get a bag. The reason why I know, I look at the least lethal way to subdue someone is because I look into those police excessive force cases. And there's some things they could do. And I used to have this argument with my uncle. Shout out to my uncle who committed suicide. He was a federal agent. Yeah, that's why I talk about this stuff. Because go ahead and think you can get away with bad behavior now and your life be crazy. But with that goes to say, I love him. I used to have these talks with him, like, why do y'all kill people? I used to be like, why do you shoot people and kill people? He's like, because if we don't shoot to kill, then they gotta get up. And I'm like, what? I was like, well, you can't just shoot them in the arm to disarm, things like that. And that is why I evaluate things based on de-escalation. So I don't want violence, but I think the best place he should have did it was in the gut. Moving forward, witness statement number 2, the confrontation. A second witness, eyewitness, 16-year-old testimony, and close friend of the victim, provided his account of the event leading to the stabbing. The unwanted visitor. He testified that the students of Centennial High School, later identified as Karmelo Anthony, entered the tent after the rain stopped. The group told him to leave multiple times, but he refused. So that's a little weird because the next testimony is going to say that they saw Karmelo Anthony and someone else looking for a place to go under the rain after being displaced, being somewhere else. But that's why they say it was contradictory. And the defense did not allegedly, because of this good old boy deal. Okay. Bluffing. The witness believed that the defense was bluffing. This is the minutes. This is the us watching, like, what is going on here. They were really like some antagonizing going on. And you telling me one person can antagonize the person who started it? I mean, they can antagonize each other. It can be a two-way street, but I didn't appreciate the way it was just put on Karmelo. Like that was really bad. But now we understand why, because all of them just could have went to jail. So the witness believed that the defendant was bluffing, and it was a high school track meet. A weapon was selective. The defendant came irritated and proactive, reaching into his backpack and saying, "Touch me and you'll see what happened." That's the minutes. That's the time. Nobody around stopped it. Am I wrong? We all purple here and we're all adults. Would you handle that? Would you want your kid to do that, to be around doing all of that? Heck no. the shove. Austin became annoyed and frustrated by the defendant's refusal to leave. He probably was like cracking jokes, saying obscene things, like what he was saying, stuff that was getting us mad. And I don't know, but I'm gonna be honest, based on this sweetheart deal, I don't know what Karmelo does. Karmelo probably got a potty mouth. There's something that they were trying to hide from his cell phone, some behavior issues, and that's the real with that. So I can probably see Karmelo digging in somebody's butt with their mouth and talking crap. And it's escalate to the point that then you're physically touching somebody, and that was not Karmelo who did it first. So that's why we're here today asking the why such a harsh sentence. All right. So now we're moving forward. The testimony, the stabbing, and the aftermath. Again, the witness was looking away at the moment of the stabbing. So they really didn't know what was happening, which makes them a little bit uncredible because their back was turned, as well as allegedly. Everybody back was turned at this point, even everybody arguing. And even Metcalf, surviving twin brother, was looking the other way. I started a fight and I'm just looking the other way. Everybody's looking the other way. That's weird for me. He looked back to see Austin was with blood on his chest, falling down the bleachers. Austin was screaming, he stabbed me. Okay, let's move forward. All right, we're going through these testimonies just a little bit so you can see now because at first I was reading this and I was mad, like, what these people lying for? Something ain't right. Something ain't right. But now I understand the why, because possibly these kids could have been charged. No cap. No cap if we had a real system. So cross-examining memory versus evidence. The evidence is very blurry. Okay, so everybody memory a little blurry too. So during the cross-examining, the prosecution challenged the first eyewitness recollection of the event, contrasting his testimony with the video evidence reviewing at the incident. Another thing that was a failure on the defense side is that they did not use the children's testimony with the police against them. It was alleged that the police, and y'all saw the evidence exhibit. It ain't got no police reports, none of that in there. That's why I said, please don't take this case on appeal. I got to be honest, because it should be more information in there. If they got and captured all of this, then it would have showed like things were suppressed, things were supposed to come in. Where could you show it? From hearsay? He acknowledged that seeing video evidence of the stabbing in the meeting with the prosecution on April opened his eyes and changed his perspective. Okay, the prosecutor presented the video timeline suggesting that the witness and his testimony were not looking towards the memorial tent in the 15 seconds leading to the stabbing. Okay, the concept of memory being fallible was discussed with the witness agreeing that the mind can play tricks and attempt to form a narrative from a fragment of what it saw, as well as what I told you, group thinking. After talking, watching, seeing things, you start saying the things that the other people said. Just like Austin said, the surviving twin said, yeah, when I turned around, the way he said it, I forgot what was the statement, but it was like in third party, like he was repeating what someone else said. He said, by the time I turned, he was like, he went in the bag and got something. Then I turned around and saw him. How did you know he went in the bag and got something before you turned around? I think that was the statement. These were things that were supposed to be caught, but they were not caught. Okay. So now I think we went into enough as far as the witness statements. Let's just get into, before we get into the podcast form, where you're going to listen to the jurors entrapment. We're just going to listen to this real quick. We're going to hit a few more clips. I want to say thank you. And the reason why we do this, because we have to bring light to this case. Tomorrow, they're going to be pushing the hearing to see what happens. And we need to be fully aware of what to expect, what was the real scenario, not be emotional, and start thinking of ways to strategize to get this boy time down for real, because they did him wrong.
To get to new developments in the track meet stabbing trial.
Yeah, the jury just heard from several students and school resource officers who were there at Kirkendall Stadium when Austin Metcalf was killed.
Senior crime and justice reporter Rebecca Lopez is live at the Collin County Courthouse. Rebecca, what testimony stood out to you?
Well, Cynthia, there was a lot of new information that came out today. We did hear from the students that saw the stabbing. We also heard from the paramedics who tried to save his life, who tried to save Austin Metcalf's life. We also saw the weapon that was used, and we saw body cam footage. So a lot going on today. We are using sketches from our courtroom artists because cameras are not allowed inside. Jurors watched video of Karmelo Anthony moments after the stabbing as police took him into custody. The school resource officer who arrested Anthony testified students pointed him to the suspect. He told jurors that Anthony immediately admitted what happened, saying, "I'm not alleged, I did it." Jurors, though, also saw photographs of the knife used in the stabbing. Witnesses described it as a utility tool similar to a Leatherman. And they also watched that body camera video in which Anthony could be heard crying, repeatedly saying Metcalf put his hands on him and asking officers if Metcalf was going to be okay. Earlier, a paramedic testified that Metcalf had no pulse when emergency crews arrived and described the extraordinary measures that were taken to try to save his life. We also again heard from multiple student witnesses. They gave differing accounts. Some said that they were both aggressive. Both Anthony and Metcalf were aggressive, but that it was Karmelo Anthony who escalated it. But on cross-examination, they said it was Austin Metcalf who might have been the aggressor, that he went and shoved Karmelo Anthony in like a linebacker's kind of drill, and that Anthony was sitting there just talking to his friend and was actually sitting outside the tent. So a lot of new details that we have not known until this trial started, Cynthia.
Now, I just want to put this because people always put in like propaganda, but I don't know if this is the truth, but let's examine this because we always have our others that make up stuff and justify. Now, listen to this. Is this true? Because I never heard this day in my life. Carmelo was actively suspended for carrying a knife to school, brought a knife to the track meet, then provoked other teams, allegedly. Now, we see the provocation is not real. So we deal with facts there. Now, you're saying that he was suspended for bringing a knife to school, allegedly. We never heard of that. But then we have to think about it like adults. Why is a young person bringing a knife to school? Why are they so nervous? Why are they thinking about carrying a knife? Why? It's the why for me. Was there some type of bullying or something going on? Was there an underlying tone that I have to protect myself? You know, me coming from Newark, I already know I had to have some mace or something. So if I came into school and I got in trouble for having mace or something, it was literally because I know that they was going to come to the school and fight afterwards. I don't give a damn. Somebody going down. So to bring that statement, this is what you get from Mama Grace. Let's expand on that. Even though I don't totally believe it's the truth, because this has what been going on with the case. People just throw stuff out there and it's highly ridiculous. We got to do better. So if you have facts on that, send it to me because I will love it. I'll present it here because I know something was going on with Karmelo behavior that made this lawyer make this sweetheart deal. Something was going on allegedly with the phone and it's something, but that right there, I'm not totally sure, but I love to examine it. And as mindful adults, we have to think of the why. Why would a kid do that? How do we stop this from happening again? Okay? Yeah. Like, why are kids shooting up schools? How do we stop that? Why do they feel they have to do that? Not just put metal detectors there and laws. What the hell is going on in their mind? Okay, this is what we got to do here. Okay, so I appreciate your comment, but I'm telling you, I'll be a lawyer. I'll be a good debater around you. I'll be saying, I got something for everything. I'm going to make you think. I'll make you think.
Yeah, Rebecca, we've seen a lot of protesters right outside the courthouse there. What's the atmosphere like right now?
Chris, there have been times when there have been protesters shouting at each other. There have been some protesters out here shouting racial slurs, and that gets everybody hyped up. But I will tell you, the Collin County Sheriff's Department has this under control. They have quickly quelled and de-escalated the situation, and they are watching everyone. They're keeping track. They are very well staffed, and they say that they're going to make sure that everybody here does have the right to a free speech, but that they do it in a respectful and legal manner.
You threatening people, talking about they're going to hang and talking about something. oh, why you talk about racism? Y'all saying the same shit that your ancestors said, and they actually did. Yeah, I got us because y'all know I'm blacker than black, even though I don't like that term. I'm a Hebrew. I'm gonna make y'all remember why these tones come up because you have dick buckuses out there saying shit like that. Excuse me. Excuse me. We got genetic threshold pain levels from this. That's what comes out from Grace Levi sometimes. Shout out to the Levi's, the Zoes, Judah. Right here, Judah is for you. Black Americans, I'm doing this for you because they killing us. They killing us all. But shout out to Judah. So with that goes to say, if y'all want information about the court filings, this is the website that you guys can go look. Y'all can read about the new pending motions, and that's what we're going to get into now. We're going to do a brief review through podcast form of highlighting how the judge handled the jury, holding them hostage, how he gave the jury directions, which was inadequate, and that is some of the things that they're actually going against in the paperwork. So let's just get to it before we get to the podcast form. I think we cooked a little bit. Thank you for being here with Miss Grace. If you like to talk about things from a legal perspective, a humanistic perspective, and a badass perspective, and God watching us perspective, hit the like button. It is what it is. Now, moving on, let's get to this is what they want. So the first motion, defense motion for a new trial, another a motion to recuse. So I think the one on the 19th is the recusal and the 20th is for a new trial. So the removal is basically based on the judge's action. A special hearing is being held by the appointed visiting judge. Okay, and we don't know too much about this guy, but I told TikTok to go get some information. So the defendant's arguments for this motion, Anthony attorney argued that Judge Roche displayed explicit bias after the jury trial, specifying that he cited post-trial media interviews where Roche agreed with the jury decision, characterizing Anthony as a nice, young, wholesome American man. He didn't say that, but yeah. He said Anthony as a nice young man who committed a crime that urged the commentary. It says they argue that the commentary proved he had not remained neutral. I don't know how strong that is, but like I said, we're gonna listen to the podcast, and again, I want to read everything verbatim. I know he made some messed up statements, and he wasn't supposed to. We already knew that he was biased from the beginning. Maybe if they have some proof that he's connected to the family, I think it'll help. But the statements, I'm not 100% sure, because when it comes to judges' opinions, they can write an opinion about a case, and that becomes a form of like case law review. And you can use a judge's opinion as like a third level reference in the case. So a judge have a right to write a legal document of a judge's opinion. So that's what I'm thinking. I don't know how strong this is. So that's just my opinion. That's what we got going on. The next one is to get a new trial. Separately, Anthony defense team is presenting arguments to have 35-year murder conviction thrown out in favor for a brand new trial. They have put forward several constitutional procedure arguments. Public trial violations. This is some of the things that we talked about. The defense claimed that the tight restriction placed on the public media access to courtroom during the initial trial violated Anthony's civil right constitutional right to open trial. So basically what they were doing was once he decided to have an open courtroom, he restricted to a certain amount of people. Then he closed off the overflow, and that was the time when they were picking the jury, which restrict the how can I say the openness of the case. This is the way from some of the things that I read. of how they're approaching this. Okay. So broken legal agreement is the next violation for a motion for a new trial. His lawyer alleged that the off the record agreement with the prosecutor was violated, which ultimately prevented Austin from testifying in his own defense. And we want to get into that a little bit more. And the last thing is the flawed instructions. And I mentioned this, and I didn't even know they had this in the appeal. The judge's instruction means the world. It'd be like, this is law, this ain't law, this what you got to do, this what you got to do. First and foremost, they said that the judge's instruction was so damn hefty that this judge didn't want to read it. He told it was going to be fast, and he gave him a copy of the thick ass judge's rule handbook, whatever, which was unprecedented to me, because some people are not going to understand it, because you were supposed to interpret it for the juries. So right there, that is strong right there. The flawed instruction. Also, allegedly, this broken legal agreement, if it wasn't put on paper, I'm not sure how much would it be, but it is within the transcripts where they acknowledge that it has a broken agreement, and that he said, hey, so we had this agreement that we can't talk about persons or talk about history of this person behavior or whatever. But then the judge came in and said, hey, if you get on this stand, we're going to basically bring up everything that we want to bring up about you. You can't be mad if the prosecutor says this, that, and the third. Boom. This is what restrict Karmelo from saying anything or feeling like he should say anything, because this is when it changed. And then you have the defense like, hold up, wait a minute, I restrict my cross-examine, all types of stuff, because I knew I couldn't bring up persons, things like that, because I would have been brung up going on with Austin, the bullying, the cheerleaders. We could have did it all, allegedly, in my synopsis. So this is why they're like, hey, ground for a new trial. I think the ground for a new trial is much stronger than the recusal of the judge, unless they got some other facts. Now, I know he severely, grossly, tried to, how can I say, condense the viewership of the court proceedings, but they should have had another ground for recusal. We need another ground, in my opinion. I just gotta say that. So let's move forward. This is where you can get this information, so you can read it yourself. And now we're going to get to law and crime, and we're just going to listen a little bit about law and crime, and then we're going to get into the podcast. Okay, it's a long night. We cooking. Let's hear what he got to say real quick. Let me put this what's Facebook up there. Let's put him up there. Again, my name is Miss Grace. Please hit the like button. I am not monetized. Don't plan to be monetized. I just like to tell the truth, examine cases, and expose them damn crooks. I got that tongue out. Sorry, y'all. Sorry.
It's your boy Gerald with the NC Beat. We are back with part 3 of me going through this motion for a new trial. Before the first day of this trial, I made a video about how Judge John Roach issued an order regulating the access to the trial. In the motion for a new trial filed by Karmelo Anthony's appellate legal team, it said that Judge John Roach's order regulating the access to this trial violated Karmelo Anthony's 6th Amendment right to a public trial by materially restricting public access to trial proceedings without findings and alternatives required by Waller, Presley, and Stricker. In this motion for a new trial, they're basically arguing how these restrictions violated Karmelo Anthony's right to a public trial. They put in there how the courtroom opened at 8:30 for the media, open at 8:40 for designated family members, and only at 8:50 a.m. for the general public. And Judge Roach,
which caused them to scramble, to have issues, for the race thing to be going on outside. It was total chaos. Total.
Roach's order, the doors to the courtroom would close at 9:00 a.m. And if you go in and you leave out, you could not come back in until the next recess. Remember when I told y'all on June 1st and June 2nd that Monday and Tuesday, we were downstairs on the first floor in this big room, and they had video and audio inside of the courtroom where they were doing voir dire. Wednesday, we were off.
voir dire means that they were choosing the jury selection, okay? And that is the next issue that they had within the motion to recuse him. I think it was the jury selection, but I have to just double triple check.
On Thursday, the room that they allowed the public to go inside of for jury selection on Monday and Tuesday was closed. And so they brought that up in this motion. And they said that Judge Roach closed that room without announcement, without a court order, or findings on the record why he was closing that room. Karmelo Anthony also argued in his motion for a new trial that the public access was further strangled by a curfew that Judge Roach put on the parking lot. And the times were 11 o'clock p.m. The parking lot will close until 6 o'clock a.m. the next morning, and it will open. That was for the duration of the trial. And they also argued that members of the public who wanted any real chance of getting inside of the courtroom had to begin lining up between 4 and 5 o'clock in the morning. And I ain't gonna tell y'all no lie. One day it was 3:30 in the morning. And their motion is supported by a lot of sworn affidavits. And they argue that the restrictions was a partial material closure of the courtroom during every critical phase, or considering reasonable alternatives as the law requires in Waller versus Georgia, Presley versus Georgia, and two recent cases decided in Texas, Stricker versus State and Hernandez versus State. And I pulled up those case laws because this right here is what pigeon-toed Sarah J. Fields will not tell you. In this motion, public access to this high-profile trial is one of their biggest arguments. Now check this out. One of the case laws that Karmelo Anthony's legal team used in this new motion for a new trial is a case about a woman named Jennifer Jo Stricker. She was on trial for theft. You can see right here where it says that she was sentenced to prison for 14 years for stealing between $150,000 and $300,000. But in trial, during jury selection, her attorney had asked if one of her friends could sit in the courtroom as a spectator, and the judge said no. The judge's reasoning is that there...
Now, this is the case that I broke down to you guys yesterday, so we're not going to go back into it, but this is the case that they're using for foundation of the open court violation. Now, the last part where I told you I just wanted to verify, it was the Fourth Amendment violation, due process and fair jury. So beyond the broken agreement, the defense pointed to the structural issues regarding the overall fairness in the instruction of the jury. So we went into that. The claims of defense argued that the instruction provided to the jury prior to the deliberation were highly misleading regarding how to evaluate Anthony's claim of self-defense. They also pointed to the fact that the prosecutor used premeditated strikes or removal all remaining black potential jurors from the pool, resulting in an all-white 12-person jury. The constitutional issue, the Fourth Amendment protects a citizen rights, due process, and equal protection under the law. The defense argued that the misleading jury instruction and biased jury selection tactically and fundamentally corrupt the trial neutrality. So if you guys want to know exactly what the law behind a jury selection, it is the Boston Challenge. Okay, so a Boston Challenge is a legal objection rise during the jury selection when one side believes the other is using race, gender, ethnicity to eliminate potential jurors. Named after the landmark case in 1986 Supreme Court case Boston versus Kentucky. This mechanism ensures that defendants' 14th Amendment right to equal protection is not violated by discrimination or jury selection. So also let's keep in mind, guys, that we're in a Trump tone, and that America, I'm just being honest, and that was one of his first things he tried to dismantle was the right to fight against discrimination. So let's just keep this in mind. Okay, I just thought about that, because the tone behind society also shapes the way that courts react and approach. Okay. So in Karmelo Anthony's case, his defense team is using Boston style argument to claim prosecutors intentionally struck black jurors out to create a all white jury. When the defense team issued the Boston challenge, the judge must immediately pause the proceedings and follow a strict three-step legal test. Now, that's why I said I have to read all of the transcripts and everything to see was this brought up in the midst of court, and I would have hoped so and assumed so, since they're bringing it up on the hearing and possibly in an appeal process as well. It has to be on the record somewhere, allegedly, but I can't say it till I actually read it myself. So the defense established the prima facie. I do apologize. The defense must first demonstrate the baseline interference that discrimination occurred. Okay, so this right here is, I'm gonna be honest, it's hard to establish unless at the time that when you was asking the questions, the questions centered around some type of discriminatory area like color, culture, and not based on circumstances around light cases. Like, for instance, when I had to choose my jury for my traffic case, they asked the jury, have you ever did a jury? Have you ever been pulled over by a cop? Have you ever received a ticket? Those were good questions. Now, or they couldn't ask like, oh, okay, do you think black people get pulled over more? Like things like that. So they will have to find those inferences in the questions to pull forth with the Boston challenge. That's what I said. That's a little hard for me. Just like, whoa, okay, that's a lot. But moving forward, does that make sense? All right, let's move forward. So the prosecution must provide a race neutral reason. The judge agrees that the defense meets the initial burden. Okay, if they do that in the step one, the focus shift entirely to the prosecution. The state must provide a clear, specified, and racial neutral explanation for why they struck those individuals. So during the proceeding, if the defense acts like, hey, did you do that based on race? They have to give a reason like, no, because he got a lot of tickets. He just probably will be mad at police. We want someone who's non-biased. Things like that. That could have been a response. Okay. The judge ruling on the pretext. Okay, this was supposed to happen if they brought this up in the middle of the trial. So in the final step, the judge evaluate both arguments and make a definitive ruling. The judge must decide if the prosecutor stated race neutral reason and genuinely or simply a pretext for covering up and intentional discrimination. So that is what the last part of this motion for recusal, because it had to possibly be brought up some way, somehow for them to use it in the hearing. So let's see what happens so you guys can understand how that will break down and if it don't work. Okay. So now what we're going to do is get to this one. How many? We an hour and a half. Y'all want to do at least 2.5 hours. So we're going to do 20 minutes. No, at least to the last, because I'm going to take a break, y'all. I won't be back till later on this week. So let's cook on this. Give Karmelo some love. And yeah, let's play this right here. We're going to get to Law and Crime TV as they break down the evaluation on that. And then we're going to get to the last part, our AI podcast, guys. This one really interesting, though. It's interesting. It didn't get me mad. I was mad at the last one, like, damn, the defense didn't do nothing. Nothing. I was like, this podcast got to be biased. And they wasn't. That was what the heck was in the filings. The defense did nothing. Let's play this real quick.
The only thing between...
So I don't know, guys, how an appeal will work, especially if the same judge is on there. I think we have to do a sentence reduction. That's my opinion. It's my opinion. But I'm not a lawyer.
On the judge who oversaw the teen's trial that ended with him being convicted of murdering fellow athlete Austin Metcalf at a track meet.
He put his hands on me. I told him not to. He put his hands on me.
We have the hundreds of pages of documents claiming the...
You hear my baby Karmelo. He was in so much pain. And I know people like, Metcalf died. But he was going through it. Them people, something bad happened in them 7 minutes. Oh my God, I hear the pain in my baby. In his voice.
Judge overseeing the trial made some major errors. Now, Anthony's team is calling for the guilty verdict to be thrown out entirely. We will also talk about an alleged off-the-record deal that Anthony's defense team made with prosecutors that his new lawyers say set the now convicted teen killer up for failure. We're on the case presented by Law and Crime. I'm Chris Stewart.
All right, let's get to here.
Of the incident, it was shot from a surveillance camera on the top of the football stadium. It shows some commotion, shows a potential shove from Austin Metcalf, but the moment in question, the stabbing of Austin Metcalf, is something you really cannot see. But this surveillance video was big evidence at the trial. Anthony was reportedly under Metcalf's team's tent. Metcalf wanted Anthony to leave. Anthony did not leave, and then Metcalf shoved Anthony, and in that moment, Anthony pulled a knife out of his backpack and fatally stabbed Austin Metcalf once in the chest. The jury took roughly 3 hours after hearing testimony to reach a guilty verdict.
Now, remember, guys, y'all got to stay for this last part because you're going to hear the breakdown on how the judge basically coerced, locked up the jury, threatened them, and all types of shit. It was bad. It was bad.
In the days after the verdict, Karmelo Anthony filed a notice that he would be appealing the verdict, and these filings appear to be the first step in that process. Now, there were 2 documents that were filed. One is calling for a new trial. The other calls for the judge who oversaw the trial to be recused from any future proceedings on this case. So I want to start with why this team believes that Karmelo's guilty verdict should be tossed. Anthony's lawyers are arguing that his Sixth Amendment right to a public trial was violated. They say that this case received national attention, and yet the proceedings, they argue, were kept out of public view. Audio and video recordings were not allowed. We couldn't live stream it. We were only getting reports from a small number of credentialed media members inside the courtroom, and we were able to have one of those reporters, Cody Thomas from Court TV. But as far as the public, we did see lines out the door throughout this trial, but for the public, there were roughly only 24 seats in the courtroom. Dozens of people lining up outside. There was an overflow room, the appeals attorneys argue, but they say that room was eliminated. Now, in the document, Anthony's team also has anecdotes from people who traveled from places like North Carolina and Arizona in hopes of witnessing this trial.
These are the witnesses that they have in the motions that I was mentioning. Shout out to Law and Crime, because I'm looking at it right now like, Dag, should I bore y'all and go through it? I got like the first 15 pages printed, but he hit it.
But they say they weren't allowed in. Now, the decision not to allow cameras, live streaming and audio recording, that was made by the judge. And this is what that judge said in an interview with WFAA television after the verdict.
I'm doing this interview with you to make sure that people understand how the system works. And if they really wanted to, and I mean this seriously, if they wanted to, they could have stood in line with everybody else.
We're going to talk more in just a moment about the issues that the Anthony team now has with Judge John Roach and what he had to say in that interview. A big part of this trial also was the fact that Karmelo Anthony didn't testify. Many people have wondered what went into that decision. If he was so scared for his life, why not tell the story on the stand? According to Anthony's new team, a lot of it had to do with what they say was an off-the-record understanding between the defense and prosecution. So this is what it says. Anthony's appeals team said in May of this year, the lead prosecutor on the case reached out to the defense and proposed they, quote, try the case clean. And that would mean they would make this case only about what happened under the tent instead of offering character or reputation evidence. Now that's
crazy. That was the worst agreement ever. Just like I told y'all with the excessive force, the Supreme Court just ruled that now when you're evaluating excessive force in police case, they can look at the totality of the situation. So now it won't look like everybody's getting railroaded now and all the police are innocent, because if you look at the right in the circumstances, everybody's going to be scared. Somebody's going to do something stupid. But if you look at the totality of what led to it, then you can make an adequate decision. And this is stupid for the defense. I would have just said, he a regular kid, he get in trouble, he did something on his phone, fuck it, let's go. Y'all can show what y'all want to, but we about to show who is the baddest. I would have just let it all come out.
Deal was off the record. And they say the reason for that was so the media wouldn't get word about it, because it's probably something we would see in court filings or through local media reports. Now, Anthony's team says that his defense was then limited under that deal at every stage of the trial. They say the defense could have presented statements that trial witnesses made to police, like saying that Austin Metcalf was, quote, kind of like the aggressive guy on the team. They say that there's a student who told police that Austin would get, quote, triggered. And they also say that there's a witness who told police that Austin and his twin brother Hunter refused to be disrespected. They also say under this off-the-record agreement, the defense didn't bring any expert witnesses who could have talked about how Karmelo Anthony's epilepsy could have impacted his perception of threat, or how the fact that he has an adolescent brain, he was only 18 years old when all of this happened, how his brain wasn't fully
developed. I didn't watch this. So obviously we're on the same page because we all purple here. We got common sense and we're looking at it from a social aspect. What the average person with common sense would do. What's a social norm? Not culture, not I'm black, I'm white, I'm in charge, I'm this. What is a cultural norm that we all can meet at the middle? And we're saying the same thing. Shout out to law and crime.
Developed, and that may have impacted his ability to have a fight or flight response. Now, the truth is, we don't know if that was presented. Would that have changed anything in jurors' minds? They reached a verdict after 3 hours of deliberations. Now, here is where Anthony's new team says the off-the-record deal restricted him from being able to testify, because they claim that the plan was for Karmelo Anthony to testify about the altercation that he had with Austin Metcalf, and under this deal that they say exists, that he wouldn't have to worry about his character being attacked on the stand. But then they allege on June 8th, which is the second to last day of this trial, the day before Anthony would have taken the stand, the team alleges that prosecutors went back on the deal. They say that the deal never contemplated a testifying defendant. And they also claim that the defense opened the door to character testimony, because in the opening statements for the defense, they mentioned that Karmelo Anthony liked to play chess, which had nothing to do with what happened under the tent. They say, quote, when the moment came for the defendant to make the
Oh my God. So they said once that the defense said that Karmelo liked to play chess, the agreement went out the window. And I would like to add that the judge directly and exclusively pulled Karmelo out and had a one-on-one conversation with him of the extent that he can expect from his testimony, and made him know that everything was going to come out. And to my understanding, that was unprecedented for him to have a one-on-one conversation with Karmelo intensely for 20 minutes about that before he made a decision, allegedly.
most consequential
Railroad. That's why I have the name. That's why I said, was Karmelo railroaded? Were they all working together to do this?
decision of the trial, whether to waive his Fifth Amendment privilege to testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. The Anthony appeal team also talks about the speed at which this trial moved, which did include a full day of testimony on a Saturday. They also mentioned that the jury was told that they would be sequestered to a hotel if they didn't reach a verdict that day. Not only is the new team of lawyers for Karmelo Anthony arguing that his guilty verdict should be tossed, they say that the judge who oversaw the case should be recused from future hearings. Now, a big part of that argument has to do with this interview that Judge Roach gave to WFAA after the verdict.
Did the jury get it right?
Yeah, they did. You know why? Because they were picked based upon the law. They listened to the facts. They happened here in this very courtroom. And they got a verdict. And so that's the process. And whatever they say, they get it right.
All right, so we're going to stop right there. And I want to say a shout out to Law and Crime on Case. I'm going to put both of these big content creators' information down at the bottom, which is Chronicle Speaks, which was a dope breakdown, as well as Law and Crime. Now, before we go into our last section of this podcast, of this live is the podcast form, you're going to hear a word from our sponsors. I want to say thank you so much for being here with Miss Grace Levi, Mama Grace, while we're here cooking on the truth, trying to get, people back to being human and dealing with reality. Okay. So if you guys don't know, I love to do my due diligence. And I want to say shout out to my sponsors, Primetime Home Buyers, which is me. Hit the like button. Girl.
Blowing cash on random TikTok trends? Instead, dive into Real Estate Monthly Info Sessions. Next level smart move. These sessions make real estate investing feel like a cheat code. Unlock wealth, understand tax lien auctions, and mitigate risks without the stress. Crazy affordable, like a Netflix subscription for your financial future. With thousands attending, it's legit. Wealth, knowledge, ease, don't miss out. Sign up now.
Struggling to break into the real estate market? The Alternative Real Estate Investment Seminars are the game changer. Tired of traditional opportunities that seem out of reach or too mainstream to yield significant profits? Enter a smarter path with our expert-led seminars designed for aspiring investors eager to explore tax lien and deed investments. This platform offers tailored consultant services and detailed strategies for lucrative returns. Dive deep into expansive learning with on-demand real estate educational seminars and seize the moment to transform investment dreams into reality. Ready to unlock potential? Check us out today.
All right, you guys, we're back. Now,
I
what
feel
we're
like we
going to
usually
do
think of the
is
justice system as this.
stop. What we're going to be doing is listening to a podcast form. Okay. Again, if you guys don't know, I broke down the transcripts in podcast form because there was just a lot to go over in a short time. And I wanted to present as much factual information to you guys as possible when it came to this case. Okay. So we're going to listen to this podcast together. I'm going to get into the audience. I will probably jump in and out to give my commentary. You guys get in there and let me know what you think. This is non-biased breakdown of what occurred in the last 3 days of the trial, how the judge tried to basically hold the jurors captive, not giving adequate jury instructions, as well as other things. Okay, so let's just hit the like button. I want to say thank you for being here with Miss Grace. Thank you. Let's go.
Like grand public monument, right?
Oh, definitely. Like very transparent.
Yeah, exactly. We pictured these old courthouses with heavy wooden doors flung wide open to the public square, the grand marble columns.
Right. Viewing galleries just packed with citizens.
Right. Because the entire architectural philosophy of a courthouse is built around this idea that justice is something you can, and honestly, that you must see happening. Like, if the state is going to take away someone's freedom, they have to do it in the absolute light of day.
Yeah, transparency isn't just, a best practice in the legal system. It is the load-bearing pillar of the whole structure. The process is supposed to be completely visible to anyone who just wants to walk in off the street and watch the gears turning.
But then you encounter a case where those heavy wooden doors get deadbolted.
Right.
And the windows are tinted, the official record is sealed, and suddenly that grand public monument feels a lot more like a walled fortress.
Which is a huge problem.
It is. And that's what we're getting into today.
Welcome to today's Deep Dive. We are so thrilled to have you with us. Today, our mission is to analyze the core claims demanding a complete retrial in a very high-profile Texas murder case.
And we have a massive stack of sources on our desks for this one.
Oh, we really do. We are looking at the actual defense briefs, the appellate motions, court transcripts, and even transcripts from local media interviews.
Yeah, it's a really compelling body of source material, mostly because it forces us to confront what happens when the mechanics of justice kind of retreat into the shadows.
Right.
When we talk about appeals, I think people often assume the argument is about whether the jury made the right choice, like whether the defendant is actually innocent.
Sure, like a whodunit.
Exactly.
Yeah.
But an appeal of this nature is entirely different. It asks whether the process itself was fundamentally structurally fair.
So let's just lay out the foundational facts impartially so you, the listener, know exactly what we are dealing with here. We are looking at the state of Texas versus Karmelo Anthony.
Karmelo, who was 19 years old at the time of the trial, was convicted of the murder of Austin Metcalf. This was following an altercation at a high school track meet, and he was sentenced to 35 years in prison.
And throughout that trial, the defense argued self-defense.
They did. But now, the appellate defense team is demanding a completely new trial. They're asserting that the original proceedings were just compromised by the severe escalation of unfairness that infected basically every level of the process. So, okay, let's unpack this. We're going to trace this escalation, and it really starts before you even step foot inside the courtroom.
Yeah, the defense's foundational argument here is that the court instituted this access regime that foreseeably and systematically excluded the public. They are alleging a structural public trial violation under the Sixth Amendment.
And the details of this access regime in the defense briefs are just staggering to read. It began 10 full months before the trial even started.
With that gag order, right?
Exactly. A sweeping gag order. Nobody with first-hand knowledge of the case was allowed to speak to the media for 10 months. But it's the physical access to the courthouse that really paints a vivid picture.
Oh, the curfew.
Yes. The court instituted an overnight curfew on the entire courthouse campus, running from 11 p.m. to 6 a.m.
Which you don't see every day.
You really don't. And why did they do it? Well, because out of a courtroom that held roughly 70 people, only about 24 seats were actually made available to the general public. So people who were desperate to get a seat just began lining up in the pre-dawn hours.
And law enforcement was actually stopping people at the parking lot until that 6 a.m. curfew lifted. So you essentially had this chaotic line forming in the dark, administered without any clear published standards on, like, how seats would even be distributed once the sun came up.
It sounds less like a public institution and more like an exclusive nightclub, you know, like with a bouncer holding a clipboard at a velvet rope.
That's a really good way to put it.
Because imagine your loved one is on trial for their life and you can't even get in the building. According to the briefs, the defendant's own grandfather and his aunts were excluded because the court instituted a strict 8-seat cap on the family.
Wow.
And there's this specific anecdote in the filings about a woman named Thelma Anderson.
Oh, yeah, the line jumping situation.
Right. She arrives super early. She's 7th in line in the dark. And somehow, inexplicably, she gets bumped to 35th and completely misses the morning session.
Just bumped back with no explanation.
None. And another woman is physically removed from the courthouse because of the expressive content of her clothing.
Well, and a crucial element the defense points out here is the overflow room. Because the court did initially provide an overflow room with a live video feed during the jury selection phase.
Okay, so that seems reasonable, right?
It does. But then on the very first day of actual testimony, like the exact moment the presentation of evidence began, the court just quietly eliminated that overflow room.
Just turned it off.
Completely. There was no announcement in open court, no written order justifying the closure, no findings placed on the record. The feed was just gone. No video, no audio.
So if you were one of the dozens of people turned away at the door, you had zero way to know what was happening inside.
Exactly.
But I do want to pause here for a second just to play devil's advocate, because judges do have to manage security and space, right?
Yeah.
They can't realistically let 1,000 people cram into a 70-person room just to satisfy public curiosity. So I'm trying to figure out why this crosses the line from, standard administrative space management into what the defense calls a structural error that automatically demands a new trial.
Well, I mean, what's fascinating here is how the Supreme Court has structured this specific right. A judge absolutely can restrict access for security or space. But under a landmark precedent called Waller versus Georgia, if a judge is going to close the doors to the public, they must navigate a very strict two-pronged test.
Okay, what are the prongs?
First, they have to make specific on-the-record findings that justify the closure. And second, they must consider reasonable alternative.
Like, say, keeping that overflow room open, or just providing a live audio feed on a website.
Precisely. And the defense argues the judge did neither of those things on the record. And this is the mechanism of a structural error. Most legal mistakes are subject to what we call harmless error analysis.
Right.
If a judge accidentally admits a minor piece of irrelevant evidence, the appellate court just asks, did this actually change the outcome of the trial? And if the answer is no, the verdict stands. But denying public access without meeting those Waller requirements is treated totally differently. It is a structural error.
So it's kind of like a contaminated crime lab.
Yes, exactly.
If the entire lab environment is contaminated, you don't waste time trying to prove whether one specific DNA test was altered by the bad environment. The structure itself is compromised, so you just have to throw out all the results and start over.
That is a brilliant way to frame it. The secrecy itself is the injury here. The defense doesn't have to prove that the lack of public spectators actually changed the jury's verdict, because the Sixth Amendment right to a public trial doesn't just belong to the defendant. It belongs to you, the public.
Right.
It exists to serve as a check on the system, just to ensure the state isn't condemning citizens in secret.
And according to the filings, that culture of secrecy didn't just stay in the hallways with the locked doors. The defense claims it bled directly into the judge's chambers and, severely infected the legal strategy itself. They claim they were gutted by a broken off-the-record handshake deal.
Yeah, this transition from physical exclusion to procedural informality is really where the constitutional crisis deepens in this appeal.
The appellate brief refers to it as the Try It Clean agreement. So in early May, which is weeks before the trial began, the prosecution and the defense met in the judge's chambers. And crucially, this was off the official public record. They agreed they weren't going to use any character evidence or bad act evidence against either the defendant or the victim. They were just going to stick to the raw facts of the altercation itself.
Which is where the concept of detrimental reliance. Right. You altered your position to your own detriment based on an agreement, and the other party took the benefit and then completely pulled the rug out. In law, that creates a binding obligation, even if it wasn't a formal written contract.
That makes total sense.
Yeah.
And looking at the filings, the defense here gave up a massive amount of leverage based on that verbal promise.
Oh, huge amounts.
They had witness statements showing the victim had aggressive tendencies, like statements saying he got triggered and could be a bit aggressive at times.
Yeah.
And they intentionally didn't bring any of that up on cross-examination. Plus, they completely benched their expert witnesses.
Which is a huge sacrifice in a murder trial.
Seriously. They had a neuropsychologist ready to testify about the defendant's epilepsy and how it chemically affected his threat perception. And they had a forensic psychologist prepared to explain adolescent brain development and the fight-or-flight response. And they shelved all of it just to honor this unwritten deal.
Because their entire strategy was meticulously built around a very specific payoff. The defendant, Karmelo Anthony, was going to take the stand and testify about his internal perception of the threat, entirely free from character assassination. And in a self-defense claim, the defendant's state of mind is the cornerstone of the whole case.
But then comes the rug pull.
Right.
It's Monday, June 8th, the final day of evidence.
Yeah.
The defense has played by these unwritten rules for the entire trial, holding back their experts and their cross-examination. And right before the 19-year-old defendant is about to take the stand to tell his story, the prosecution suddenly announces that the agreement never contemplated a testifying defendant.
It's just wild.
It is. And they claim the defense already opened the door to character attacks because during opening statements, they mentioned that the defendant played chess.
Yeah, claiming that mentioning a board game opens the door to a person's entire character history is quite an aggressive legal leap.
It seems absurd. Like, playing chess opens you up to character assassination. So the judge steps in and says he has no mechanism to enforce an unwritten deal. And this is the part of the brief that really gave me pause. The judge gives this 19-year-old kid just 10 minutes.
Just 10 minutes.
10 minutes to decide the rest of his life. He has to choose whether to risk testifying and facing this barrage of character attacks he wasn't prepared for, or stay silent and essentially forfeit his entire self-defense narrative.
The psychological weight of that moment in that room must have been just crushing.
Absolutely.
And he ultimately chooses not to testify.
It's a devastating tactical blow that effectively neutralizes the defense.
I do have to push back a little here, though, on behalf of the state. Because these defense attorneys are highly educated, highly paid professionals. If this Try It Clean agreement was the absolute linchpin of their entire case, isn't it kind of their own fault for not getting it on the official public record?
That's a fair question. Like, why should the appellate court grant a completely new trial for what sounds like a rookie administrative mistake by the defense team?
Well, if we connect this to the broader principles of due process, the legal system recognizes that the state holds a deeply disproportionate amount of power. The defense in this appeal relies on a Supreme Court precedent called Santabello versus New York.
Yeah.
That case establishes a core rule. When the state makes a promise and induces the defendant to rely on it to their detriment, the state cannot legally abandon that promise at the final hour.
Even if the lawyers were sloppy and didn't write it down?
Even then. Because the issue isn't about punishing the lawyers, it's about protecting the fundamental fairness of the trial for the defendant. The state received a massive benefit here. The defense held back their aggressive cross-examination. They held back their medical experts. To then repudiate the deal right when it was the defendant's turn to reap the benefit, it essentially coerces him into waiving his Fifth Amendment right to testify.
Wow, yeah.
It honestly doesn't matter who forgot to hit the record button. If the state induces a strategy-altering reliance and then breaches that trust to silence the defendant, the process is structurally broken.
So the doors to the courtroom are effectively closed to the public. The defense's medical experts are benched. The teenage defendant is silenced. The defense is basically backed into a corner before closing arguments even begin. But the escalation continues.
It gets worse.
It does. The defense argues that it was the judge's instructions to the jury that delivered the final fatal knockout blow to their case.
Yeah, because jury instructions are the critical intersection where the raw facts of a trial meet the strict interpretation of the law.
And here's where it gets really interesting. Because in popular culture, we just think of juries as 12 people sitting in a room deciding what happened based on their gut.
Right, like they just chat about it and vote.
Exactly. But they don't have free reign. They only decide the facts based on the highly specific legal rules the judge hands them right before they deliberate. And the defense claims the judge handed this jury a faulty rule called the provocation instruction.
Now, the law of provocation is incredibly narrow. It essentially means that you lose your legal right to claim self-defense if you intentionally provoked the other person into attacking you, simply so you could have a pretext to use deadly force against them.
So it's like intentionally poking a bear with a stick, just so you have a legal excuse to shoot the bear when it charges you?
Exactly that.
But the defense points out in their appellate filing that there was absolutely zero evidence presented at trial that Anthony provoked this altercation as a pretext to hurt the victim. Like, you can't just be involved in a mutual fight. The law requires a preformed design, a specific intent to create the occasion for deadly force.
Right, and providing a jury instruction without a firm evidentiary basis is highly problematic in appellate law. Jury instructions act as the filter through which all testimony and evidence must be viewed.
And the prosecution knew exactly how powerful this filter was. In their closing arguments, they leaned on this provocation instruction heavily. They explicitly told the jury they could use this specific rule to completely throw out the self-defense claim.
Which is incredibly damaging.
It feels like handing the jury a loaded narrative weapon right before they go into the deliberation room, a weapon they legally shouldn't have been given access to in the first place.
It raises profound questions about the purity of the deliberation process. I mean, if the filter the judge provides is legally warped, the resulting verdict is inherently tainted. You cannot give a jury a legal mechanism to dismiss a defense if the foundational facts don't support the use of that mechanism. The defense is arguing that this single unsupported piece of paper destroyed their only viable path to acquittal.
Which brings us to the fourth and final element of this appeal. And honestly, the part of this deep dive that reads the most like a Hollywood legal thriller.
It really does.
The defense is essentially arguing that even if an appellate court looks at the closed doors and the broken unwritten deal and the fatal jury instruction and thinks, well, maybe none of these individually warrant a new trial, the sheer cumulative weight of all of them combined surely deprives a citizen of a fair trial.
The cumulative effect, yes.
But the story doesn't end when the gavel comes down on the verdict. The defense also filed a motion to recuse, meaning they want to legally ban Judge John R. Roach from having any involvement in the appeals process.
And the foundation for that recusal motion rests almost entirely on the judge's own extraordinary post-trial actions.
The sequence of events is just wild. The trial ends. Karmelo Anthony receives a 35-year sentence. The original defense team steps away, and the new appellate lawyers come in to start analyzing the trial for errors.
Right, the appeals team.
So they go to the courthouse to get the official case file so they can actually do their jobs. And they're told they aren't allowed to see it.
Which is baffling.
The judge has sealed the entire case file by an oral order.
Did you hear that, guys? Obstruction. I'm sorry, I just got to add something. This is ridiculous, but let's finish listening. This is very interesting. I love the way they broke this down.
Which is an incredibly rare and frankly hostile roadblock. A transparent public docket is the absolute baseline requirement of the appellate process.
Right. And the judge tells these new lawyers they can only look at the file inside his chambers, and only if they agree not to disclose what they see to anyone else. It's a complete catch-22.
Oh, entirely.
A defense attorney, obviously, cannot agree to keep the file a secret if their entire job is to write a public appeal based on that file. But while the lawyers are
Mary, we said what at the same time. This is my second time listening to this. It is amazing. So I do support the steps that they're taking cumulatively, as we talked about.
fighting just to see the paperwork, Judge Roach does something that blew my mind when I read the transcripts. Just 2 days after sentencing the defendant, while he still actively holds the power to rule on a motion for a new trial, Judge Roach goes on local television.
Yeah.
He sits down for an on-camera interview with WFAA-TV.
A local news broadcast speaking directly to the general public.
Yes. And on television, he explicitly defends his courtroom access restrictions. He tells the reporter that keeping the cameras and the streaming out was an easy decision. He says he struck a pretty well balance between security and access.
Unbelievable.
And then, when the reporter asks him directly about the jury's verdict, the judge explicitly endorses it. He says on camera, yeah, they did get it right, and states as a matter of fact that the defendant committed a crime.
Wow.
If I could hypothesize for a second here, if a judge goes on television to publicly defend a verdict, it seems to me they are basically becoming a witness or like an advocate for the state.
Yeah.
Doesn't that make it legally impossible for them to act as a neutral referee on the appeal? Like, how does an appellate court actually evaluate judicial bias in a scenario like this?
You've hit the exact legal mechanism on the head. When appellate courts evaluate a motion to recuse, they aren't necessarily tasked with proving that the judge harbors deep secret malice in their heart. The legal standard often hinges on the appearance of bias.
Wow, the appearance of it.
Exactly. The foundation of our entire legal system relies on the judge being a completely neutral arbiter. You cannot publicly vouch for the correctness of your own controversial rulings and publicly endorse a guilty verdict on television while you are simultaneously the person sitting on the bench tasked with objectively deciding if that very trial was constitutionally flawed.
You literally cannot grade your own homework on the evening news on Tuesday and then pretend to be an objective grader in the courtroom on Wednesday.
This happens a lot in our courthouses, and I'm going to tell you, I see it all the time. The judges and the prosecutors, they, like you said, that's my prosecutor, and they should never make a statement like that. But I have heard judges say that they are supposed to be the ref in this court. But I can see, okay, that's why I don't mind going after judges too. So guys, just a heads up, I have a few other personal things that I share with you guys as far as me going after small town big corruption. So turn your notifications on, okay? Let's finish listening.
It completely destroys the appearance of neutrality. The defense argues, and the law generally supports this idea, that a reasonable member of the public would severely doubt that a judge who is publicly committed to the fairness of a trial could then impartially weigh a defense motion asking him to declare that same trial unconstitutional. The well is poisoned.
It is just a staggering escalation of events to review. So let's briefly recap the 4 core claims we've analyzed for this retrial demand. First, the escalation began at the courthouse steps with a secretly closed courtroom where the public was walled off by pre-dawn curfews and bait-and-switch overflow rooms. Second, the secrecy bled into chambers with a broken, unrecorded handshake agreement that coerced a teenage defendant into silence and gutted the defense's medical evidence.
Yep.
Third, the unsupported provocation instruction that handed the prosecution a fatal legal weapon to defeat the self-defense claim in the deliberation room. And finally, the crushing cumulative weight of all these structural errors, topped off by a presiding judge going on the local news to defend his actions and endorse the conviction before the appeal process had even begun.
And you know, it is vital to understand that these aren't just obscure technicalities or bureaucratic missteps. These procedural rules, the open doors, the binding agreements, the accurate instructions, the neutral judges, they exist to protect everyone, including you, the listener.
Exactly.
They are the structural guardrails of liberty. If the state is permitted to close the doors without justification, break unwritten deals without consequence, and issue unsupported instructions that tip the scales of justice, the system fails us all. The process is the punishment, and the process must be fair.
Which brings us right back to where we started today. We inherently expect our grand monuments of justice to be transparent. But I want to leave you with a profound paradox to mull over as we wrap up.
Okay.
The judge in this case issued a sweeping 10-month gag order that legally silenced everyone involved, with the stated noble goal of protecting juror impartiality and ensuring a fair trial. But then, literally days after the sentence is handed down, that exact same judge goes on television to declare the jury got it right, while the defense's motion for a new trial is still sitting pending on his desk. If the grand public monument of justice has its doors locked and its windows tinted to keep the public out, but the architect of the trial is outside giving press conferences about how perfect the building is, who is really protecting the integrity of the court?
That is the question.
Thanks for joining us on this deep dive. We'll catch you next time.
Welcome to This Explainer. We're jumping straight into a massive legal controversy that actually strikes at the very heart of.
So here, you're going to hit and break down the motions real quick, and then we're going to start to wrap up this live. I want to say thank you for being here with Miss Grace. Thank you for expanding your horizons. We do things a little bit different here, but I know when you sit down and listen, you learn a lot. So listen to it on your break, while you're at work, working, cooking in the kitchen. Please hit the like button so you can get more notifications about Miss Grace Levi deep dives. We got plenty more for you.
The American justice system. We're looking at the high-profile murder trial of Karmelo Anthony. Now, this case ended with a conviction and a 35-year sentence, but right now, the spotlight isn't just on that verdict. It's on the courtroom itself. The defense has filed a motion for a new trial, and they are alleging a severe structural public trial violation. They're arguing that the way this trial was administered fundamentally shut the public out. And we really need to break this down, because an open courtroom isn't just about one single trial, right? It is an absolute bedrock of democracy, designed to ensure transparency for all of us. To truly wrap our heads around this legal argument, we have to ask a very practical, real-world question. What actually happens to constitutional transparency when a trial of this magnitude, one drawing huge national attention, collides with the strict physical limits of a local courthouse? How is a judge supposed to balance courtroom security and decorum with the Sixth Amendment right of the public to actually witness justice being served? Well, according to the defense's motion, the balance struck in this specific case crossed a very dangerous line. They argue it went from standard administrative management straight into unconstitutional secrecy.
Okay, so let's unpack this core concept. The defense is claiming a structural public trial violation took place. Basically, the Constitution demands that if a judge is going to close a courtroom to the general public, they have to pass what's known in the legal world as the Waller test. This means the judge has to make specific, on-the-record findings that justify closing the doors, and they absolutely must consider reasonable alternatives first. But the defense argues that through a maze of administrative rules, the court functionally closed this trial without ever meeting those strict, mandatory legal standards.
Let's kick things off with Section 1, secrecy before the trial.
You see, the public's exclusion didn't just magically begin on the first morning of jury selection. According to the defense, the groundwork for a closed-off process was actually laid way before anyone even stepped foot inside the courthouse. Over 10 months before the trial, the court issued a massive, sweeping gag order. And what's really notable here is that the judge issued this sua sponte, which means he did it entirely on his own accord. Neither the prosecution nor the defense actually asked for it. This order silenced pretty much everyone involved: parties, witnesses, law enforcement, even court staff. They were banned from discussing the character of anyone involved, expected testimony, or the evidence. If you wanted to talk to the news or post on social media, you had to get explicit written approval from the judge. It was an incredibly tight lid, and it was backed by the threat of contempt, fines, and attorney discipline.
And while that gag order kept all the participants completely quiet in public, the actual, substantive, legal heavy lifting of the case was moving behind closed doors. The defense points out that crucial pre-trial negotiations were held entirely off the public record, quite literally inside the judge's chambers. This even included a pivotal, unrecorded evidentiary agreement about character evidence that ended up profoundly shaping the entire defense strategy. So think about it. If a regular member of the public had checked the public docket before the trial started, they would have found absolutely no hearings to attend and no substantive pretrial motions to read. The public record was effectively completely dark.
Moving right along to Section 2, the seat math and visualizing scarcity. When you're dealing with a trial that has the whole nation watching, the physical space obviously becomes your first major bottleneck. And the basic arithmetic of the 296th District Courtroom is incredibly revealing here. Out of roughly 70 total seats in the room, the general public was left with a surprisingly tiny slice of the pie. The court-appointed public information officer allotted 15 seats to the prosecution's family, 15 to the defense's family, and 9 to the media. Once you factor in all the necessary court staff, that left only about 24 rotating seats for the general public. And to make matters worse, the defense notes that even those allocations weren't strictly honored.
Exactly, because they said they only let about 27 people into the courtroom. So, excuse me, that's so crazy. Because if each side had 15 people who could come in, that's already over the amount that they actually let in. This was
Wow.
For instance, the defendant's own family was capped at just 8 seats in practice, which meant his grandfather and aunts couldn't get in. This math created an absolutely massive scarcity for the public.
Which brings us to Section 3, the pre-dawn lottery and curfew.
So if you've only got about 24 public seats for a nationally watched trial, how on earth do you decide who gets them? Well, the court managed this extreme scarcity by requiring folks to navigate a daunting maze of logistical hurdles. Right before the trial, the court enacted an overnight curfew on the entire courthouse campus, running from 11 p.m. to 6 a.m. The rules dictated that the public doors would open at 8:50 a.m., but astoundingly, they locked promptly at 9 a.m. If you were actually lucky enough to snag a seat, you couldn't leave and re-enter unless there was an official recess. On top of all that, the court imposed a strict ban on anyone wearing clothing deemed distracting. That is a highly subjective rule, adding just one more hurdle to observing a high-stakes murder trial. The absolutely crucial point here is that this setup left members of the general public with exactly a 10-minute daily window to enter the courtroom. Just 10 minutes, from 8:50 to 9 a.m. If you arrived at 9:01, you were totally locked out until the next recess. But let's be real, with only about 24 seats available, showing up at 8:50 a.m. meant you had virtually zero chance of actually getting inside. Because of that strict curfew and the severe lack of seats, the actual queue, the true line that determined who would get to see this trial, formed hours before dawn. The defense details how everyday citizens began lining up between 4 and 5 in the morning at the edge of the courthouse parking lot, just waiting in the pitch dark for this 6 a.m. curfew to lift. These are just average citizens trying to access their justice system, but instead they're subjected to a pre-dawn lottery administered by sheriff's deputies. The defense points out that this line was managed without any published standards. People who had waited for hours in the dark were sometimes suddenly displaced by individuals claiming media credentials, meaning the public's few seats were completely exhausted before the sun even came up.
Now for Section 4, the vanishing overflow room.
Usually, a court with limited seating can easily set up alternative viewing accommodations. And initially, this court actually did. But the very core of the defense's constitutional argument hinges on a sudden, completely unexplained overflow bait-and-switch. On May 29th, the public information officer announced that an overflow room with a live feed would be available. On June 1st and June 3rd, during jury questionnaires and voir dire, an auxiliary room was successfully utilized by the public. But then on June 4th, the exact day the actual witness testimony began, the overflow room was eliminated entirely. No prior notice, no public hearing, and absolutely no on-the-record findings from the judge.
And the defense wasn't just speculating here, they had the receipts. They anchored their claims in documented reality, pointing directly to emails from the court-appointed public information officer. When people who had literally flown in from out of state, folks from Arizona and North Carolina, asked where they could watch the trial after being turned away from that tiny courtroom, the official response was stark. In writing, the official stated, "There is no overflow room."
That means for a trial of immense public interest, there were exactly 0 overflow seats, 0 live audio feeds, and 0 video live streams available to the public once the testimony actually kicked off. The court simply did not broadcast the proceedings to anyone who couldn't secure one of those roughly 24 physical seats during that tiny 10-minute morning window. The bitter irony here is that the constitutional accommodation existed only when no witness was actually testifying. Television monitors were set up and audio was provided for jury selection, but the exact moment the state began presenting its core evidence against the defendant on June 4th, the overflow just vanished. Lines of 80 to 100 people outside resulted in only a tiny fraction being admitted. And this total blackout remained in effect through the closing argument.
And this is when the secrecy really kicked in. And this is why they have grounds for this motion.
The guilty verdict, and the swift imposition of a 35-year sentence. Which brings us to our final section, Section 5, seeking a new trial. All of these compounding administrative restrictions, the gag orders, the off-the-record chambers meetings, the 10-minute entry window, the pre-dawn parking lot lines, and that vanishing overflow room, all of it culminated in the defense taking decisive legal action. They formally filed a motion for a new trial based on a structural error, arguing that the court completely bypassed that Waller test we talked about earlier. Remember, a judge is totally allowed to manage their courtroom, but if their rules foreseeably exclude the public, they have to justify it on the record and consider reasonable alternatives, like, just keeping the audio feed turned on. Because the court bypassed these constitutional safeguards, the defense argues this isn't just a minor procedural glitch. It's a structural public trial violation that demands the entire judgment be set aside.
Now, you know what's really interesting?
Following the trial, the judge publicly defended his restrictions in a televised interview with a local news station. He called the decision not to stream audio or video an easy decision, and remarkably stated that he felt he struck that balance pretty well, asserting that the public could have just stood in line with everybody else. As you can imagine, the defense is now utilizing these very public statements to further highlight that the denial of alternative access was a deliberate choice by the court, not just some unavoidable logistical accident. So this leaves us with a truly profound legal question to consider, one that the appellate courts are likely going to have to answer soon. At what point do severe administrative hurdles to physical seating effectively violate the constitutional guarantee of a public trial? If everyday folks have to wait in a parking lot at 4 a.m. for a handful of seats with no digital overflow provided whatsoever in the modern era, is that courtroom genuinely open? It's a fascinating look at where day-to-day logistical management collides with the absolute bedrock principles of American justice. So what do you think?
All right. So the last part of this podcast is going to highlight elements of how the judge held the jury captive. Okay. Thank you for being here. I held the best for last. Let's listen together.
Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.
So if you were to walk into a murder trial today, you'd probably expect a lot of yelling, right? Like gavel banging and surprise witnesses just bursting through the back door.
No, definitely. Like straight out of a movie.
Exactly. I mean, we are so conditioned by television to expect this really noisy, chaotic collision of drama. But the real machinery that actually decides a person's life or death.
It's completely different.
Right. It usually happens in this complete clinical silence. So welcome to today's deep dive. We are actually opening up a raw, unedited court transcript today to look at the hidden architecture of the justice system.
Yeah, and the document we're unpacking, it's volume 7 of a court reporter's record.
Yeah.
This is from the 296th District Court down in Collin County, Texas.
And the date on this is June 8th, 2026.
Right. And the case is the state of Texas versus Karmelo Anthony.
So to give you a little context, we are looking at an incredibly high-stakes jury trial here.
Very high stakes. It centers around a fatal stabbing that took place at a high school track meet.
Which is just an intense scene to imagine.
It really is. I mean, you have teenagers, a crowded public setting, and obviously a murder charge. So it creates this inherently volatile environment right from the start.
But our mission today isn't to play armchair detective, right? We aren't going to sit here and debate the witness testimony or try to figure out what actually happened on that track field.
No, not at all.
Instead, we're focusing entirely on two, really pivotal behind-the-scenes moments. These are moments that happen away from the jury's eyes and then right before the jury goes to work.
Yeah, we're looking at the guardrails.
Exactly. The heavy, rigid guardrails the legal system uses to basically manufacture a fair trial. Specifically, we're going to look at the judge's intense instruction to this teenage defendant about his right to testify.
And then after that, the incredibly strict, literally life-altering instructions given to the jury right before they begin their deliberations.
Reading through this transcript, it feels a lot like getting a backstage pass to an operating room.
That's a great way to put it.
You know? You get to watch the raw mechanics of the Constitution being applied in real time. It just strips away all the theatrics to show you the clinical rules that govern everything.
Yeah, and the scene in the courtroom for this first part is incredibly stark.
Oh, completely. The jury has been cleared out. The public gallery is totally empty.
Right, so the only people left in the room are the judge, the prosecution, the defense attorney, the defendant Karmelo, and his parents.
Just them in this massive room.
Exactly. And the defense is trying to decide whether Karmelo is going to take the witness stand.
Which is a huge decision. And immediately, we see this really fascinating piece of legal maneuvering happening in the shadows.
The gentleman's agreement.
Yes. The defense attorney and the prosecutor actually reveal to the judge that they've struck a gentleman's agreement regarding Karmelo's testimony.
Yeah, so they lay out this sort of quid pro quo for the judge. Essentially, the lawyers agreed that if Karmelo takes the stand and testifies strictly about the physical facts of what happened that day.
Like just the sequence of events.
Right, just the facts of the track meet. If he does that, the state promises not to bring up Karmelo's past character or his extraneous reputation.
Okay, then in return?
In return, the defense promises they won't attack the victim's character.
Wait, let's pause there for a second. Because when they say extraneous reputation, what does that actually mean for the jury in a situation like this?
Well, it's a really critical concept in evidence law. Extraneous refers to past mistakes, prior bad acts, or just general character traits that fall entirely outside the specific crime being tried.
So things he might have done in the past.
Exactly. In a criminal trial, character evidence is incredibly dangerous. Like, if the jury hears that a defendant has a history of starting fights, for example,
They might just judge him on that.
right, they might convict him simply because they think he's a bad person, rather than because the prosecution actually proved beyond a reasonable doubt that he committed this specific murder on this specific day.
Wow. Okay, so the defense attorney is desperately trying to thread a needle here.
Trying very hard, yes.
He wants Karmelo to be able to tell his side of the story. Maybe he claims self-defense, or maybe it was a terrible accident, without opening the door for the prosecution to just assassinate his character using his past.
You nailed it.
So it's kind of like two boxers meeting in the middle of the ring before the bell rings, right? And they whisper to each other, "Look, I won't hit you in the face if you don't hit me in the face."
That's a really good analogy.
They're trying to create their own custom rules for the fight. But then the referee, which is the judge here, steps in and explicitly says, if you step into this ring, the actual rules of boxing apply no matter what you just whispered to each other.
That captures the exact mechanical problem we see in the transcript. The judge warns the lawyers very bluntly that a gentleman's agreement in a criminal case is legally fragile.
Because it's not a civil case.
Exactly. He explains that in a civil case, say a dispute over a business contract or a property line, the two parties are basically private actors resolving a private dispute.
Right, it's just between them.
Yeah, so they can make legally binding contracts about how the trial will proceed, what evidence to skip, whatever, and the court will usually enforce those agreements.
Because the stakes are just money or property.
Exactly. But a criminal trial is a completely different beast.
It's the state versus an individual.
Right. A criminal trial is the state seeking to uncover the absolute truth of a crime using a very rigid set of statutory rules of evidence. You cannot just casually contract away the pursuit of truth.
Oh, wow.
Yeah. So the judge tells the defense attorney, look, if the state breaks this gentleman's agreement during cross-examination and starts asking Karmelo about his past character anyway,
The judge can't stop them.
the judge cannot force the prosecutor to stop based on their backdoor deal. The judge will have to rule based strictly on the law of evidence.
Which completely changes the calculus for the defendant. I mean, the judge is looking at this teenager and saying, if you get on that stand, you are stepping out onto the ice. I cannot guarantee the ice won't break just because the prosecutor promised to tread lightly.
It's a huge gamble.
It sets up this massive, unpredictable risk. And because that safety net is legally void, the judge has to address Karmelo directly.
And this brings us to one of the most profound moments in the transcript, really.
Yeah, it really is.
The judge basically puts the lawyers in the background and speaks directly to Karmelo. He swears him in outside the presence of the jury to give him a formal admonishment.
Just a one-on-one conversation.
Right, and we get to see the bedrock of the American legal system, the Fifth Amendment, explained in practical life or death terms.
The judge explains this protective shield of silence. He assures Karmelo that if he decides not to testify, it absolutely cannot be used against him.
Right.
But, you know, what strikes me about this is the incredible psychological weight of that rule. Because human nature dictates that if someone stands up in a room and publicly accuses you of doing something terrible,
You want to fight back.
exactly, your immediate visceral instinct is to speak up and defend yourself. If you stay quiet, society generally assumes you're hiding something.
Right, the whole, if you have nothing to hide, you have nothing to fear mentality.
Exactly. Yet the court is imposing this
I just want to add this. Thank you, Mary, for bringing that up. But you were listening. This is what the state did. They allowed the defense to think that the agreement was good until it was time for Karmelo to actually testify. And then they told him, like, hey, if he testified, we're going to basically bring all this stuff up. This was after all of those witnesses came and defense wasn't able to, ask them the questions that they would have asked them if this allegedly gentleman agreement wasn't made. And then the judge went and reinforced it by talking to Karmelo privately and telling him, hey, basically you get in this court, this ring, the prosecutor is going to eat you alive. Okay, this is the issue here. So thank you, Mary, for bringing up all of these amazing points.
official clinical rule that completely overrides human nature.
It requires a massive leap of faith. I mean, you are asking a defendant to sit completely motionless in a chair, sometimes for weeks, while witnesses point fingers at them.
Yeah, just sitting there.
And they have to trust that the system will actually protect their silence. And to reinforce that trust, the judge points out exactly how the jury will be instructed.
What does he tell him?
He tells Karmelo that the jury will receive a strict written directive. They cannot go into the deliberation room and say to each other, well, if he was innocent, he would have gotten up and told us.
Wow, so they are explicitly forbidden from even thinking that out loud.
Do you hear that? This is part of the judge's instructions, and that's what I said it was so important for us to know what the judge told them, because he basically told them you can't think outside of what we showed you. Whatever we showed you, you can't think about it or even bring it up in deliberation.
Exactly. His silence cannot be treated as a fact or a circumstance against him for any reason whatsoever. It is a total legal override of human suspicion.
But let me push back on how this actually plays out on the stand, though. Because say a defendant does want to tell their story, but they are just terrified of the prosecutor.
Which is very common.
Right, so can't a defendant just take the stand, answer their own friendly lawyer's questions to get their narrative out there, and then the second the prosecutor stands up and starts asking the tough, character-destroying questions, just plead the fifth?
Oh, that is a very common misconception. But the legal mechanism absolutely forbids it.
Really? You can't just stop talking?
No, you can't. The legal doctrine operates on the principle that you cannot use the Fifth Amendment as both a sword and a shield simultaneously.
Okay, what does that mean in practice?
It means you cannot use your testimony as a sword to attack the prosecution's case and then pull up the shield of silence the moment they try to test your credibility.
Oh, I see.
And the judge is incredibly firm in unpacking this for Karmelo.
Yeah, the phrase he uses in the transcript is, you cannot refuse at that point and say, okay, I'm going to plead the fifth now. You have to answer those same questions.
It's an all or nothing switch.
The moment you waive your right to remain silent, it evaporates entirely for the duration of that trial.
In legal terms, we call this opening the door.
Opening the door, okay.
Right, so if Karmelo gets up and testifies about the track meet, he opens the door for the state to cross-examine him, not just about the timeline, but about anything relevant to his credibility, his state of mind, or his character, depending on how he answers.
Everything is fair game.
The judge warns him that from the moment he opens his mouth, the state can use everything he says for, against, or neutral to him.
Now, thinking from Karmelo Anthony's perspective, because he had the last and tell all, decision to testify, I don't know what he did, but I don't think anything that this young person have done will be so bad that he didn't want it on the stand. I do probably believe that he had a level of intimidation and probably wouldn't be able to handle the cross-examination, probably highlighting, his reaction to the Metcalf pressuring him and things like that. And then right after it happened, he literally is in heart-wrenching tears. I heard his voice. He was in tears. He was like, oh my God, is he okay? So I can understand in a way Karmelo not wanting to testify, being nervous, but I do believe he should have just pushed through and testified and took whatever punches the prosecutors were going to give to him. But again, if he was set up for all this time by his lawyer saying, hey, they're not going to ask you nothing bad, it's going to be focused on this, and he's been preparing for that, and there's something else happening, your whole life is on the line. This is what we have to think from all parties' perspective as well. So let's finish. Listen, we got about 7 or 8 more minutes. Thank you for being here with Miss Grace. But this is the breakdown of the pressure that was put on Karmelo, and then you're going to hear them go into the pressure that was put on the jury.
It is literally open season.
That is, you are placing an unfathomable burden on a kid. You're asking a teenager to sit in that chair and maintain total emotional composure under cross-examination by veteran prosecutors.
People who dismantle people for a living.
Exactly. The pressure in that room must be suffocating.
It is, and the system recognizes that pressure, which is why the judge ends this admonishment with a vital reminder of personal autonomy.
Reminding him it's his choice.
Yes. The judge acknowledges that Karmelo has an experienced legal team advising him, and he notes that Karmelo's parents are sitting right there in the room, but he emphasizes that when all the advice is given, the choice is Karmelo's and Karmelo's alone.
Nobody else can make it.
No lawyer, no parent, no judge can make this decision for him. It is a deeply personal, non-delegable constitutional right.
So then, the judge grants a brief recess. He tells Karmelo to go step out, go to the restroom, talk to his mom and dad, talk to his lawyers one last time without the court watching.
Gives him some breathing room.
Right. And when they finally come back on the record, the judge simply asks for the decision. And Karmelo Sincere Anthony tells the judge, quote, "I don't want to testify."
And that single sentence just freezes the entire trajectory of the trial.
It's a huge turning point.
It is. The moment he invokes that right, the evidentiary record is locked. No new facts can be introduced by the defense.
So because the defendant chooses silence, the defense rests. The state officially closes the evidence. The trial phase, as we normally think of it, is just over. And suddenly, the spotlight swings aggressively away from the lawyers and the defendant, and it lands squarely on the 12 people sitting in the jury box.
The focus shifts entirely to preserving the integrity of those 12 minds.
Yeah, the people who will make the final decision.
And the transition here is crucial. Think about it. The court has spent days, maybe weeks, carefully curating exactly what information those 12 people are allowed to hear.
Filtering out everything extraneous.
Right. So now the court has to ensure that nothing from the outside world contaminates that carefully curated bubble before they reach a verdict.
So the judge dismisses the jury for the evening so he and the lawyers can prepare the charge of the court.
Which is that highly complicated, thick packet of final legal instructions.
Right, the rules that will guide their deliberations. But before he lets the jury go home, he drops an absolute bombshell on them about what is going to happen the next day.
Oh, this part is intense.
He tells them that once closing arguments are over and deliberations begin, they are going to be sequestered.
Yeah, sequestration is one of the most extreme, disruptive tools the justice system possesses.
It really sounds like it.
It is not used lightly. But in highly publicized, emotionally charged, or volatile cases like a fatal stabbing at a public high school event, it becomes a mechanical necessity to protect the verdict from being tainted.
Well, when you really look at the mechanics of sequestration, I mean, you are taking everyday citizens who were simply called for civic duty and legally severing their connection to the outside world.
Like a 1990s sensory deprivation retreat, but with the highest possible stakes.
That is the perfect way to describe it. The judge outlines these draconian rules they're about to face. He tells them they will be taken to a hotel until they reach a verdict.
But not just a normal hotel stay.
Right. He explicitly says, and I'm looking at the transcript, the problem with the rules of the hotel are you will have no TV, you will have no phone, you will have no access to your own phone.
Just consider the immense psychological weight of that isolation for a second.
It's terrifying.
They aren't just losing entertainment, right? They were losing their connection to their families, their jobs, their entire support network.
What happens if there's an emergency?
Well, the judge explains that their families will only be given a secure emergency number to call the bailiffs in case something catastrophic happens at home, but otherwise, they completely cut off.
It creates this profound sense of legal claustrophobia. You have 12 people holding another human's life in their hands, locked in a hotel without a single screen to look at.
Just left with their thoughts and the evidence.
And the system is so terrified of outside contamination that it's willing to impose this massive psychological burden on innocent jurors just to ensure the airlock remains sealed.
It is brutal.
Yeah.
But there is a surprisingly human moment from the judge right after he drops this terrifying prospect on him.
Yeah, he kind of softens the blow.
He does. He recognizes how agonizing that isolation will be. So he tells the jury that instead of ending the court day at 5 o'clock like a normal business day, he actually plans to keep them working in the deliberation room late into the night.
Like until 10 or 11 o'clock.
Exactly.
And his reasoning is so incredibly pragmatic. He tells them, if we stop at 5 o'clock, all you are going to do is go to a hotel and sit there and stare at the ceiling, so we might as well be here and continue to work.
He's just being honest with them.
He's trying to save them from the agonizing boredom of a phoneless, TV-less hotel room.
No, he's not trying to save them. It sounds like he's trying to entrap them and force them to me. But this was some great points that this AI podcast brought up, and I'm glad it was able to break this down in such a cohesive way, because a lot of people did not know that it went down like this inside of the court.
It paints such a vivid, bleak picture of what the justice system demands of its citizens.
It's an act of mercy, really, but it also serves the court's purpose.
How so?
Well, Keeping them focused on the task at hand prevents their minds from wandering. It prevents frustration from building up in isolation. And ideally, it moves them closer to a resolution faster.
That makes a lot of sense. And that leads to the judge's final crucial warning for that evening. Before he sends them home to pack their overnight bags, he issues a strict directive about their behavior for the next 12 hours.
The ultimate gag order.
Yeah. They are not to discuss the case with anyone, not their spouses, not their kids.
And most importantly, not even each other.
Which has to be so hard.
Oh, the temptation to debrief after days of stressful testimony is overwhelming. The judge knows this.
You just want to vent.
Exactly. But he...
And then, mind you, the instructions he gave them, they can't even vent properly about the court proceedings because he said, you can't talk about anything that was not presented here. That's exactly what he said. That was crazy. No, what if, could have, because it's called reasonable doubt. And the reasonable doubt comes from the jury and their perspective. So he cut that mechanism of thinking off.
He explicitly warns them against the natural urge to bounce ideas off of each other in the parking lot or the hallway. The law requires that all deliberation happens inside that single room, with all 12 jurors present, only after they have received the final legal instructions.
He ends with a plea that I think just summarizes the entire weight of this raw transcript. He looks at this jury and says, "We've come so far and we've worked so hard, all of us. Let's don't blow it."
That phrase, "let's don't blow it," it really highlights the extreme fragility of a criminal trial.
It really does.
Think about the resources invested to get to this exact moment. The millions of dollars spent, the years of police investigation, the days of expert testimony.
The agonizing emotional toll on both the victim's family and the defendant's family.
All of it. That entire monumental pursuit of justice can be instantly derailed, completely thrown out, and forced to start over if a single juror casually looks at a tweet about the case or texts their spouse asking for an opinion on a witness.
Just one text could ruin it?
Yep. The system demands total, absolute purity at the finish line.
You know, this deep dive really pulls back the curtain on what a trial actually is. We started by comparing it to a sterile operating room, and this transcript proves it.
The proof is right there in the text.
The hidden architecture isn't about dramatic confessions or explosive evidence. It's about the clinical, almost surgical rules designed to maintain an artificial environment.
It's a highly controlled experiment.
Exactly. The court system relies entirely on acting like a perfect airlock. First, it desperately tries to seal off the defendant.
You heard what they called it, a highly controlled experiment. And that's how I feel when I'm in court.
Silence, shielding it from the jury's natural assumptions and the prosecution's attacks.
Right.
And then it pivots and tries to seal off the jury's minds, locking them away from their families and their technology to prevent any outside contamination from infecting the verdict.
It is a brilliant theoretical construct of perfect fairness.
Sure.
Really, it is the best mechanism we have devised to ensure that a person is judged solely by the facts presented under oath and nothing else.
But looking at the reality of how these rules are applied leaves you with a really provocative thought to ponder.
Oh, for sure.
Because we are talking about a trial in the year 2026. We live in a hyper-connected digital age where information, opinions, and news are beamed directly into our pockets and onto our smartwatches every second of the day.
It's inescapable.
Right. So the idea of true hermetic isolation seems almost physically impossible now. Is this level of absolute purity achievable anymore? Or is our entire legal system currently relying on an outdated honor code, desperately trying to hold back an unstoppable tide of outside information with nothing but a judge's strict warning and a hotel room without a TV?
All right, y'all. I want to say thank you for
So the date has
being
been
here with
set
Ms. Gray.
in the Karmelo Anthony motion to recuse Judge Cockroach.
Let's remember what's happening in the next 2 days.
Judge Cockroach is set for August 19th in Collin County, 9 a.m. And it's not restricted from the public. So that means you need to be there because we recall Judge Cockroach attempted and succeeded at limiting people of color from having access to make sure that justice was administered fairly. So what does that mean? That means that you need to prepare to be there in support on August 19th. So essentially what that means is that you want to attend, you need to prepare to be there because the clear people are going to attempt to do exactly what they did under the power of Judge Cockroach. So make sure you show up, you be prepared.
The other night I cried for the 12 tribes. We've been through a lot. They still taking our lives. What we gonna do? Who is gonna save us? I think I got a clue. Yeshaya the savior. Here they come with the guillotine. We about to bounce up out of here like a trampoline. To the wilderness we about to flee, cause we ain't never get no love, call it Billie Jean. Judah in the window, but you know we got 11 more kinfolk.